The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Mr. Drennan, you may proceed.
Thank you, Judge Gregory. My name is Joseph Peter Drennan, and may it please the court. I represent the appellant in this action, Yusuf Abdi Ali. Mr. Ali is a legal permanent resident of the U.S. who resides in Northern Virginia. He's also a former colonel in the Somali National Army who has resided in the U.S. for decades. The complaint in this case was filed on the 13th of June, 2005. That complaint contained a number of allegations of wrongdoing against my client, Ali, by the plaintiff, Warfa, in the December 1987 to March 1988 timeframe. Warfa brought his action under the Alien Tort Statute and the Torture Victim Protection Act. As the court knows, this case has been up before the court a couple of years ago on our immunity defense, which was found to be unavailing. However, the court did affirm Judge Brinkema's dismissal of the Alien Tort Statute claim. So the TVPA claim is the only claim that remained extant. That claim carries a 10-year limitations period. How long did it take Warfa to bring his action? It took 15 years. Why did Warfa wait 15 years to file this case? Well, the Warfa's counsel pleaded equitable tolling. Their contention was that Warfa could not have brought his case for many years during the 1990s because of allegations, generalized allegations of conditions in Somalia that were not conducive to bringing suit or investigating a complaint. We, in terms of narrowing this matter down, conceded that Warfa could not have brought suit in Somalia, but we've abided by our limitations defense, and we've abided by our contention raised in the answer that was ultimately filed, that that Warfa is not entitled to equitable tolling. Why is Warfa not entitled to equitable tolling? Warfa is not entitled to equitable tolling because his experts, which constituted the only putative proof of adduced for equitable tolling, made no reference whatsoever to Warfa's individual circumstances. Rather, they just made broad brush descriptions of the shambolic state of the courts and of security within Somalia. They made no reference whatsoever to any particularized contentions of hardship or inability to either investigate a suit or file a suit on the part of Warfa. Indeed, there's perusing the two expert reports, there's no contention that those...
Counsel, let me ask you, are you saying investigate to file a suit in Somalia or the United States?
To file a suit in Somalia, but to investigate to file a suit in the United States, but to investigate in Somalia. In fact, it's particularly noteworthy that...
Well, didn't he have the former American ambassador testify at some length about conditions in Somalia during that period of time?
Well, let me reference that. For one thing, the procedural history of this case is that Judge Brinkema granted a last-minute motion for partial summary judgment on limitations virtually on the eve of trial. The ambassador came in and testified at trial, but I was not able to question him regarding issues relating to the limitations period. And if Your Honor would review the record of the ambassador's testimony and of his expert report, his testimony and his report were both focused on the conditions in Somalia prior to and at the time of the occurrence of Warfaw's allegations regarding harm that was visited upon him. The Siad Barre regime fell in 1991. There is no evidence whatsoever anywhere in this record, anywhere, as to where Warfaw was during that period, what Warfaw's witnesses were doing during that period. So how could...
Mr. Drennan, this is Judge Diaz.
Yes.
So as I understand the case law, though, in this area, it's not necessary that the plaintiff who's seeking tolling show that there's a particularized threat or inability as to him, but that if general country conditions suggest, as in this case, that there was a civil war ongoing, that alone is sufficient to at least allow a court to reasonably conclude that a plaintiff can't reasonably pursue his remedies while that unrest is ongoing. Do you disagree with that, or have I misstated the law?
I do in part, Your Honor. We have, as I referenced at the top of this argument, we have conceded that Warfaw could not have brought suit in Somalia. We do not concede that he could not have brought suit in the United States during the period for which he claims equitable tolling. He has never even asserted that he was in Somalia during that period. And even if he did, he still would have to make an allegation and offer some proof of particularized circumstances causing hardship to him. And for that, Your Honor, we rely on the Supreme Court case, the 2015 Supreme Court case of Menominee Indian Tribe of Wisconsin versus U.S., which set forth a two-pronged test to determine the availability of equitable tolling to a plaintiff. The plaintiff is only entitled to equitable tolling if he establishes the following two elements. One, that he has been pursuing his rights diligently, and two, that some extraordinary circumstance stood in the way and prevented timely filing. Your Honor, respectfully, there's no affidavit or declaration from Warfaw as to what he was doing during that period and why he was not pursuing his claims or making an effort to pursue his claims.
Well, Mr. Drennan, can I, so just to follow up, so as I understand the plaintiff's allegations, and I think Judge Brinkema agreed with this, that even if the plaintiff could lodge a claim in the United States, that it would have been, it was reasonable for him not to pursue the claim sooner than he did because of the fear of reprisals, whether to him directly or members of his family, and that is sufficient given the country conditions in Somalia and Somaliland to suggest that even if he could theoretically file a suit in the United States, that it would not be unreasonable for him not to do that until things had settled down in his home country. So what about that?
Your Honor, respectfully, what about that? He still has to make some intention that he has pursued due diligence to bring these claims. He never even made a contention that he did. And when what the plaintiff is asking for here, what the appellee is asking for, is for some special exception for TVPA cases. How do we even know that Warfaw was in Somalia during that period? And as for a question as to why didn't I ask him, he has the affirmative. He has the burden of proving that he exercised due diligence, and he offered no proof whatsoever. Neither of those experts that submitted those reports upon which Judge Brinkema relied and upon which your Honor has been referencing, neither of those reports contain any reference whatsoever to Warfaw's particularized circumstances. It's quite apparent. It's quite apparent that they never even met Warfaw, never considered his individualized circumstances, never interviewed him, and rather they take the position that there is some kind of blanket exception that this litigant is going to be treated differently than any other litigant merely because he happens to be a Somali national. We don't even have him in Somalia during that period. I challenge my opponent to come up with one scintilla of proof in the record that Warfaw was in Somalia, much less that he made any.
Mr. Drennan, you want to take a second?
I turned it off, Runner. I apologize.
All right.
Much less that he undertook any efforts to pursue his claim.
Mr. Drennan, Mr. Drennan, Judge Diaz, can you hear me? Sorry. So I guess I want to ask my question again, maybe a little bit more directly. So even, and of course, we'll ask your colleague on the other side to answer that question you just posed. But even if the plaintiff in this case might not have feared personally for his own life, wouldn't it be reasonable for a plaintiff not to pursue a claim in the United States, assuming he was outside of his home country, if he feared that members of his family, for example, would be retaliated against if he filed that claim in the United States, the members of his family in his home country? Don't you think that would be sufficient for a judge to consider equitable tolling? Possibly,
if and only if he adduced some particularized fact circumstances that supported that fear, and he did not. Rather, he had two experts just opine generally, and that is insufficient. That does not meet the two-pronged test set forth in Menominee Indian tribe. It doesn't meet the first prong, and it pursued the matter diligently. There's absolutely no indication that he did. I see that I'm over time. Yeah.
All right. Thank you, Mr. Drennan.
Thank you, Your Honor.
All right. Mr. Schmidt.
Good morning, Your Honors. May it please the court, Paul Schmidt from DLA Piper, on behalf of the appellant, Mr. Warfa. The issue today is whether equitable tolling applies to Mr. Warfa's claims under the Torture Victim Protection Act. The district court resoundingly answered yes to that question twice. This court should affirm that ruling. I just want to start by sort of framing this dispute. Mr. Ali's counsel has discussed how there's no facts or circumstances suggesting some sort of particularized harm or particularized fear on the part of Mr. Warfa. And I think we're sort of missing the forest for the trees here, because this is a case involving serious human rights abuses. As alleged in the complaint and as proved at trial, in December 1987, Mr. Warfa was kidnapped on Colonel Ali's orders from his village in the northwestern region of Somalia. And he was targeted not because he had done anything wrong, but because he was a member of the Esau clan, which was being persecuted at the time by the Bahraini regime. Mr. Warfa was thrown into a dank cell, repeatedly beaten until he was unconscious, and tortured over the course of several months. He remained in custody for 2 years under the hands of Mr. Ali and the Bahraini regime. And afterwards, after he was released, out of fear of his life, he had to go to a refugee camp in nearby Ethiopia. Until January of 1991, when the Bahraini regime fell, and when Mr. Warfa returned to Somalia, there was no way, while in prison at the hands of his torturer and his persecutor, and while having fled the country in Ethiopia, to Ethiopia until 1991, there was simply no way that Mr. Warfa could have investigated his claims. Investigated from a cell? Investigated while he was being tortured? This is simply strange reason to even suggest this. Subsequently, the country, after January 1991, when the Bahraini regime fell and Mr. Warfa returned to Somalia, the country plunged into a state of chaos and remained in that state until at least January of 1997. Mr. Warfa brought his suit in November 2004 under the TVPA, and I would like to correct the record. The first complaint was filed in November of 2004, not in June of 2005, as my esteemed counsel suggests. In the process of passing the statute, Congress recognized that extraordinary circumstances are innate in most TVPA claims and that equitable tolling should apply. Mr. Warfa's suffering and the history of this case present the quintessential circumstances in which equitable tolling applies under the TVPA. And we should understand at the outset what Colonel Ali is asking you to do today is extraordinary. There was already a trial in this case. A jury found after 3 days of testimony that Colonel Ali was liable for Mr. Warfa's torture. Colonel Ali doesn't challenge that verdict or any of the trial proceedings here today. Rather, he wants it just simply thrown out and start over again and further delay justice for Mr. Warfa. And let's be clear, let's talk about the district court record in this case. In holding that equitable tolling applied,
Mr. Schmidt, can I ask about that, what you just said, that all that that Mr. Ali is interested in is throwing out the verdict and starting over again. But I mean, if he's right that equitable tolling doesn't apply, the claim would have expired, right? You wouldn't be able to start all over again.
Well, that would be a question on remand, Judge Diaz, for the district court. The posture of the case when the issue was presented before trial was a pretrial partial summary judgment motion, which was brought by Mr. Warfa, the plaintiff. So going on the scenario where, for some reason, this panel found that equitable tolling did not apply, given the circumstances presented at summary judgment, the proper course would be to remand to the district court. But I can't even imagine how that would happen, Your Honor. But again, it was not Mr. Ali's summary judgment motion; it was the plaintiff's summary judgment motion upon which this issue was brought. But I'd like to ask
another question unrelated to that. Is the test whether or not the plaintiff in this case could bring a lawsuit in any jurisdiction, his homeland, or some other place, or in the United States? Where does that answer that question, if you would, please?
Of course, Your Honor, and I'm glad you asked it. There's two issues that your question raises. The first is the jurisdictional issue of the statute. The statute provides for jurisdiction in U.S. courts. It is not saying anything about whether jurisdiction would be proper in some other forum. So what we are looking at today is whether Mr. Warfa could have brought his claim in the United States during the relevant time period or within the statutory limit. Now, there is an exhaustion of remedies provision in the TVPA, which says that the litigant has to exhaust his or her remedies prior to bringing suit in the United States, or has to show that they've exhausted remedies. And that issue has been conceded. Mr. Drennan conceded that shortly before trial and said that exhaustion of remedies wasn't an issue. I can get into the reasons from the record, but I think for purposes of this hearing, it's sufficient to say that it's a conceded issue. And I just want to, following up on your question, Judge Diaz, I just want to be clear. I want to circle back to the record that was before Judge Brinkema in the district court. She relied on a thoroughly developed record, and this was not the first time this issue had presented itself. Indeed, there was a motion to dismiss on the issue earlier. And the record that was before Judge Brinkema at summary judgment was, first of all, Mr. Warfa's allegations in the complaint as to the injuries he sustained and the time periods he sustained them. A statement from Colonel Alley himself, his own sworn declaration, was in the record as well. Facts stipulated to by the parties. An expert report submitted by Mr. Warfa with regard to, as has been alluded to both by counsel and by your honors, an expert report describing the country conditions both prior to the fall of the Bari regime in January of 1991 and then for the subsequent 6 years after that. And that report, it's important to note, that report was unrebutted, as has already been observed. The posture of the case, counsel suggests that this was sort of sprung on him or on Mr. Ali just before trial. Again, this issue had come up once before. There was no surprise that a summary judgment motion would be brought on the issue of the statute of limitations. There was a proper response time given for Mr. Ali to present witnesses or present testimony. Mr. Ali chose not to do so. And I think I'd like to, this is something that's not in our brief, but I'd like to quote the record from the hearing, the summary judgment hearing. It was a hearing to review all the pretrial motions, but the summary judgment motion was one of them. I'd like to just read very quickly a brief excerpt from the summary judgment hearing for your honors to have some context to this. Mr. Drennan, this is in the record, JA 284 and then on to 285. Mr. Drennan describes on JA 284 before Judge Brinkema their position that equitable tolling should not apply and that there's a question as to whether Mr. Ali was in the country for less or more than 10 years. And Ali's counsel, who's here today, says, quote, "That's basically our argument," to which the court responded, "All right, but the point is that evidence has not been presented to the court," meaning evidence of Mr. Ali's position. And counsel agrees, "No." And the court responds, "That's a hypothesis." And counsel responds, "That is correct, Your Honor." All they presented at summary judgment hearing was a theory for which there was no factual support whatsoever. And I just want to talk about the state of law, which I'll get into. I know I've got some time to get into the actual state of law and the case law that's been presented by both parties. But there is only consensus among the circuits, the 6th, the 9th, and the 11th. There is only consensus on this issue. And that is as to both aspects of tolling under the TVPA. So there's part one of the tolling, which goes through January of 1991, the Bari regime. There's numerous cases, as we cited in our brief, on this very issue that say that the persistence of a repressive regime tolls the statute of limitations. This has been done for situations in El Salvador, in Somalia, in Haiti, in Peru, all over the world. There's no controversy about it. And similarly, there's no controversy, there's no countervailing authority that suggests that tolling...
Mr. Schmidt?
Yes, Judge. Yes, Judge.
If I could ask you a question. Is what you're discussing now what covers the period from sometime in 1991 to sometime in 1997? Because as I understood opposing counsel's argument, it was that during this time period, your client needed to show some particularized circumstance as to him as opposed to other citizens of Somalia, if I'm understanding his argument correctly. Is that how you understood it, and what's your response?
That's my understanding as well, Judge Agee. And I just want to point the court to look at that. To look at that issue, we have to look at the case law that's on it. And our contention is that there is no requirement, once the extraordinary circumstances that were occurring in Somalia, as can be found in Mr. Gansglass's report, and Mr. Gansglass was the special assistant to the U.S. ambassador, so he has some credibility. The extraordinary circumstances that were in Somalia at the time, for the 6 years after the fall of the Bari regime, in other words, chaos, violence throughout the country, reprisals. I mean, I think in the culture, it's well known that Somalia during the George H.W. Bush administration, the end of that, and the Bill Clinton administration. It was run by warlords. There was no functioning government at all, and all this is in Mr. Ganscoss's report. And the case law bears this out. The case law has held that there's no need for a plaintiff to specifically allege or prove, in terms of the statute of limitations, there's no need for them to invoke magic words and say, I feared particular harm from such and such a person or such and such a military group or whatever. And that's borne out in the case law. Chavez v. Carranza in the Sixth Circuit, which is a case involving El Salvador. There was no evidence that the court relied upon that the plaintiffs feared any sort of reprisal or repression from the regime. And in that case, the statute of limitations was told through 2004. So the El Salvador regime fell and, excuse me, I think I might be getting my dates wrong, but the regime fell and the court told the statute of limitations for two additional years after that to account for the post-conflict scenario in that country. And the court held in the Chavez case that pleading extraordinary circumstances, i.e. the conditions in the country, was enough. In the Jean case involving Haiti in the 11th Circuit, that was involving the former regime in Haiti during the 1990s. Torture took place in 1983, and the statute was told all the way, torture took place in 93, the statute was told all the way until 94, and the court held in that case, but first of all, nowhere did the court mention a specific fear of harm from filing the lawsuit as one of the necessary allegations. The 11th Circuit case, also involving El Salvador, that case held, quote, equitable tolling is appropriate when a movement untimely files to get the Lizarbe case versus Rondon, District of Maryland case in 2009, a case involving a massacre in a Peruvian village in 1985. There, the regime lasted until 2000, and the court held that the statute could be told, quote, even though the complaint did not allege any facts specific to any particular plaintiff, sufficient to show why that plaintiff could not have investigated the events at issue. So the notion that this is some sort of ordinary claim where you have to show that you were, as for example, if you have a breach of contract, you have to investigate whether or not circumstances were sufficient to bring a breach of contract claim, or you have to, interview witnesses. That is something that doesn't fit with the TVPA. It doesn't fit with the purpose of the TVPA and what Congress had in mind when it passed the statute. And I think it is important to, when we're considering this question, to look at what Congress said when it passed the TVPA. And if you just bear with me for a minute, Your Honors. Congress passed the statute.
Before you go into that, in terms of the legislative history aspect, I want to follow up something you asked and just see whether or not the logical extent of your argument. You framed it that once you establish the extraordinary circumstances in the country, dysfunctionality, war, whatever those, the tumult is, you mean then you could plead, and you don't even have to, for example, you could have been in the United States at the time and still there'll be equitable tolling because of what is going on in that country? Are you suggesting that as well?
Well, first of all, Chief Judge Gregory, I just want to note that that's not the circumstance. That's not exactly the circumstance we're facing here. Mr. Marco was not in the United States. But putting that aside, the courts that have looked at this issue have noted, and this is in our brief, I'm happy to give you a cite, have noted that one of the reasons that equitable tolling applies in the TVPA is because it's important for the plaintiff, the victim, to be able to investigate their claims. And regardless of where the victim is, whether they're in the United States, whether they're in their original country, whether they've taken refuge in some other country, it's recognized that the hindrance of investigation, which is what we're talking about in Somalia during the 1990s, that is still at play. And that does not change. The circumstances in Somalia do not change the calculus. In other words, the circumstances of the 90s were such that Mr. Warfa could not, with any diligence, have gone into Mogadishu or anywhere where there were government records, or even his village where Mr. Ali's military force had been posted. There's no way for them to go into these areas and interview witnesses and investigate their claims and figure out where Mr. Ali is. And I think we have to also keep in mind the TVPA was passed in 1991, 1992. Mr. Warfa's circumstances were not what they are today, where today, if I want to look at and see where someone is, I can probably easily find them on the internet very readily and quickly. Mr. Warfa, the internet, I'm old enough to remember certainly that the internet was not prevalent in 1991, 1992. It started getting more prevalent in the mid-90s. But it's not like Mr. Warfa could have dialed up Google in the refugee camp in Ethiopia and figured out what was going on, what had happened, who had ordered his torture, whether there were witnesses, where Mr. Ali was. None of these things were possible at the time. There was no due diligence that was possible given the circumstances. And that's the point of the extraordinary circumstances exception, which courts have recognized. And I do want to point out, I'm sorry, Judge Gregory, did you have a question?
So your argument, fear of retribution or directed specific risk to harm, really of no moment once you establish the country conditions, that's your position?
That's correct, Your Honor. And I'd like to add something to that, which is even without, let's just say for argument's sake, this circuit, this panel wanted to go outside of the jurisprudence of the circuits that have already weighed in on this issue and say, okay, extraordinary circumstances are not enough for some reason. This falls within the statute of limitations quite comfortably, even if you only toll until January 1991, which coincidentally is both the fall of the Bari regime and when Mr. Warfa returned to Somalia. Even if you only toll until that date, January of 1991, it's still within the 10-year limit. And that is because from January of 1991 to October of 1992, as conceded by counsel, Mr. Ali was in Canada, which does not count under the TVPA. And from July 1994 until December of 1996, Mr. Ali was in Ethiopia, which also does not count under the statute. And the complaint was filed in November of 2004. It was not filed in June of 2005. The record specifically indicates, the district court record specifically indicates that the dismissal of the first complaint was taken on the condition by the plaintiff in the plaintiff's brief that it was done with a tolling of the statute of limitations. And on top of that, there's no authority presented by Colonel Ali's counsel that suggests that the statute should have been continuing to run until the second complaint was filed. This issue was waived both at the original time that the second complaint was filed. There was no contention that there should have been a non-tolling. There was no bringing up of this issue at the motion to dismiss stage, and there was no raising of this issue at the summary judgment stage. This issue has been conjured up now on appeal at virtually the last minute of the case. And I would suggest that regardless of the posture of the complaint, for Colonel Ali to raise this issue now on appeal when he never raised it before, it simply doesn't comport with the rules. And just to wrap up the calculation and the analysis, my mother is a math teacher, but I'm not very good at math. But I am good enough at math to know that when you subtract the 50 months from Colonel Ali's time here in the United States, when you subtract the 50 months from the tolling period, it brings Mr. Ali within the 120 months. It's roughly 116 months. That's in our brief. So in conclusion, Your Honor, I would just like to say that the district court ruling holding that equitable tolling should apply was not abuse of discretion and should be affirmed by this panel. Thank you very much.
Thank you, Mr. Schmidt. Mr. Drennan, you have some time reserved.
I think he's muted.
He is.
I've asked to unmute him.
Thank you.
In reply, I'd like to, or rebuttal, I'd like to address first the last contention raised by the Learned Counsel, namely his contention that the statute of limitations was told by the filing of the earlier complaint in November of 2004. That is plainly incorrect. And counsel also is respectfully incorrect when he states that the record supports that the judge ruled that the filing of the initial complaint somehow told the statute of limitations. She manifestly did not do so. She simply gave an out to a plaintiff that was unable to prosecute his case at that time, apparently, and allowed him to take a dismissal on the condition that he refile within 45 days. And he did refile within 45 days. However, at no point did Judge Brinkema rule that the filing of that complaint in November of 2004 hold the statute of limitations. That's entirely.
Mr. Drennan, Judge Diaz here, what do you think Judge Brinkema was trying to do with that conditional order, if not told the statute?
There have been cases where this sort of thing has come up before, which we cited in our reply brief. And in circumstances such as this, where the court allows a dismissal without prejudice, the case is treated as if it had never been filed. She allowed them to refile within 45 days so as to tell them that, look, you better refile or else I'm going to make this a dismissal with prejudice. However,
that sounds like she was granting, maybe not directly, a motion, allowing a motion to amend, essentially, and that I think obviously would toll the statute, right, if the case had remained live that way.
Your Honor, the case was dismissed. The new case was given another docket number. It's a completely distinct action. And if as Your Honor is appearing to consider interpreting it, that somehow this represented an amendment, she could have stayed the action. She could and she could have expressly pointed that out in her order, which she manifestly did not. So the only reasonable inference to draw from that is that the initial action did not hold the running of the statute of limitations. There was no discussion of the limitations period and how close we were to 10 years or equitable tolling or anything of that sort in that earlier record. Your Honor, what the FLE is trying to do here is rather extraordinary. They're trying to divine what the judge did in an earlier case and make a statement that this is what the judge intended, and there's no record evidence to support that. There just isn't.
Mr. Brennan, can I ask, so moving on to another topic, so your counsel on the other side cited a host of cases that he said stands for the proposition that given the nature of a TVPA claim, that extraordinary circumstances standing alone, so long as there's evidence of that, is enough to toll the statute. So are you asking, first of all, do you agree with his understanding of those cases? And if you do, are you in effect asking us to just ignore those cases or suggest that they simply aren't persuasive?
I'm asking the court to distinguish those cases, and in our reply brief, we take them seriatim, one by one, and all those cases that were cited by learned counsel, we addressed in our reply brief, and with regard to, for instance, the case involving the Haitian gentleman. There was evidence to deduce that gentleman had particularized harm and a credible case for particularized harm as to why he couldn't have filed his case. And he was targeted. You might say, well, wasn't Warpaw targeted too? Well, the problem with that analysis, Your Honor, respectfully, is that the regime that purportedly targeted Warpaw fell in 1991. What did Warpaw do after that? There's no evidence none of what Warfaw did, or even if Warfaw was in Somalia during that period. And counsel goes on to suggest that, well, it doesn't matter if he was in Somalia or not, in response to Your Honor's question. But that's not what the expert opinion addresses. The ambassador that counsel likes to refer to, his testimony did not cover at all what happened in Somalia after the fall of the regime. The expert that did address that issue did not even consider the specter of the plaintiff being outside of Somalia, and there was no consideration whatsoever given to the witnesses, whether any of the witnesses were subject to intimidation. None, nada. I mean, this is, I keep harping on this point, but the record is just absolutely stark by the absence of any evidence whatsoever as to what transpired vis-a-vis Mr. Warfaw, vis-a-vis his witnesses during that period. I see that I'm nearing the end of my water clock here on rebuttal. If Your Honor has any further questions, I'd be happy to answer them.
Thank you so much, Mr. Drennan. Thank you so much, Mr. Schmidt, as well. We would love to be able to come down in our normal tradition to greet you. We cannot do that, but know that we appreciate very much your being here and your fine arguments. Thank you so much, and hope that you will be safe and stay well. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Your Honors.
And thank you, Mr. Schmidt, as well.
Thank you, Mr. Drennan.
You may proceed.
Thank you, Your Honor. May it please the court and distinguished judges, my name is Danielle Beach Oswald, and I represent the petitioner, Mr. Douglas Leke, who is from Cameroon and was denied asylum by the immigration judge and by the board. We would ask that this honorable court vacate the board's decision and remand for further proceedings. Just briefly, Cameroon since November 2017 has been in a crisis mode where hundreds of women, children, and teachers, attorneys who are Anglophones have been killed, and there's been massive internal displacement. Even U.S. senators have pushed to protect Cameroonians from mounting violence, as the U.S. ambassador in Cameroon has also discussed. Mr. Leke went to school in Douala and worked there until he had to go back to work he went on the cocoa farm in Mayuka, which is in the Anglophone area. He was arrested on 2 occasions on May 31st, 2018 for 1 month. He escaped and then again arrested on October 28th, 2018. Villages, homes, and hospitals have been burned and destroyed, and children have been unable to attend schools in the Anglophone area, and the situation has only gotten much worse in the last year. So this is the background against which we are discussing this case. Now, throughout Mr. Leke's hearing and through his direct testimony from the jail, there was pervasive problems with the VTC technical failures between the jail and the court, and communication between the Arlington court and Farmville. The repeated instances of indiscernibles that led to impermissible speculation and conjecture, and all this, we would argue, created a lot of confusion in the parties. I don't think that there is any dispute on the fact that there was a lot of problems and that there was confusion. The judge herself said, we haven't been having this kind of trouble for a long time, dropped. problems with distortion, stuff, freezing, and everything. Today, we're having so many problems at JA 135 and 136. This isn't, again, she says at JA 140, this is maddening, really. Just 1 second. We've dropped again. I feel bad for him too, Mr. Leckie. Then again, and I can't work like this. It's torture. That's kind of ironic considering the kind of case that this is, Your Honor. And again, I hate the fact that it's the middle of direct. It's really hard on the parties. You're in the middle of direct and you're going to lose your train of thought. And then she says, this is exhausting. It's just adding to the fatigue of everything. J146. Again, in J146, she says he felt
Counsel,
rushed.
if I could ask you a question on that point. Obviously, we all are now much more familiar than we would like to be with the difficulties of the digital age. But what does your client contend that he was unable to present to the immigration judge by virtue of the technical difficulties, and where does he ever argue that he was prejudiced?
Well, Your Honor, we did argue that before the board. The problem with due process is that it does require a meaningful opportunity to be heard, and its credibility in immigration cases both pivotal and central, because that testimony alone can create a burden, satisfy the burden of proof.
Well, was there any evidence or argument that he did not get to make?
Well, looking at his declaration, Your Honor, the declaration was over 9 pages. A lot of that was not put into his testimony or asked. There was also a witness there available, his uncle, who could have testified about the chain of custody of the pictures, about a lot of different things concerning the credibility of the case, and he was not allowed to testify, Your Honor, by the judge. The communication really affects the proceedings from J38 to 237, even though they
was the exclusion of the relative, was that based on a technical difficulty or a rule of evidence?
Your Honor, my understanding was that it was when counsel asked that now they were going to have Bernard Faminka testify, the judge said, no, he cannot testify. And her, the only thing she said was that he cannot go and testify now. And apparently because he'd been in the courtroom, well, usually the government always sequesters witnesses. And I don't know why he was in the courtroom, but certainly his testimony alone would have cleared up a lot of these problems. The inconsistencies, if there were any, it would have clarified a lot of the different things. Also, counsel attempts to say, my esteemed counsel, and before that, the case is like Russo. This case is not like Russo at all, because in Russo, Russo was not resolved because he was unable to meet the second prong showing prejudice. I think in this case, demeanor and nervousness and responsiveness, which is all part of credibility, was affected by the fact that he was not able to, every time he would start, it would be interrupted. Also language.
Counsel, can I follow up on Judge Agee's question about that point? My understanding from the record is that the immigration judge in this case made an explicit finding that her credibility determination was not based on the technical difficulties, but rather based on lack of demeanor and other independent evidence throughout the hearing, beyond those that were encountered because of the technical issues. So, I mean, aren't we required to give that finding the weight that it deserves on appeal?
Absolutely, Judge Diaz. She did say that. We feel that she said that, but then yet she still made the determination based on the fact of demeanor And I don't know how she was able to make that evaluation because she did not get into specifics. Here, I think for credibility, we're looking at the totality of the circumstances. What were the issues with credibility and how does this process work? And the fact that the judge said that she did not consider that, I don't think that the record holds that to be true.
Well, I mean, demeanor is but one aspect of the credibility finding, but she made other determinations regarding his inability to explain certain factual discrepancies in the record. One of them being the fact that although he had an explanation for why in the visa application, the application indicated that he was a resident of Douala, therefore casting some doubt as to whether or not he was actually persecuted, given the geographic distance that we're talking about here. But there was a separate aspect of the record involving a marriage certificate where that same evidence appeared, and he had no explanation for that. And I don't think you've given an explanation in your brief about that. So that's just one example of the various sort of record findings that the immigration judge, I think, was entitled to hang her hat on in making an adverse credibility finding.
If I may address that, Your Honor, on his occupation and residency, if I can just briefly explain how the process works, that when a client comes across the border, what happens is they get a very detailed interview by Customs and Border Patrol. That is in ICE's record, and they do not use it or to give it to the court unless they use to impeach. So clearly here in this record, that was totally consistent what he said after traveling through all these countries. Secondly, at the border while in jail, and Mr. Leke is still detained after a year, they get what's called a credible fear interview. That interview is also a Q&A and is at page JA 558 to 571, and it's very detailed and very long and asks a lot of questions to him. Again, not a single question was asked or brought out about that, which means that it was totally consistent with his then declaration of 9 pages. If we look at his 589 application, which is the application when you apply for asylum, where you put all your information at JA 480, we see that he in fact does list the Douala address and the workplace, and all of that is listed, and his moving back and forth among Muyuka, Buya, Douala. He was on a farm. There's no address there, but he does give the correct dates in his application, in his declaration. In everything that he said, there is the correct dates. The only thing that they have, Your Honor, is, as you said, is the visa application, which he said his aunt even used her own email on the visitor's application, J215. She completed it. He gave her the information. He says that the information, of course, that he did give was correct. It just wasn't correct at that time because he was no longer working there. He said that in 212, he never saw the visa application. So here we have the marriage certificate also. Well, the marriage certificate was done in 2018, and maybe they just used his Cameroon ID or whatever. I don't know why it still said Douala. Douala is a real address. The farm doesn't have a real address. But that is, those two things are the only things, one of which he had nothing to do with. The other things, his application 589, his credible fear, his CFI, his declaration, which is very long and detailed, his daughter's birth certificate, which was done in 2018 at J240, all of those say that he specifically lived in Muyuka, which, by the way, Your Honor, and throughout the record, it's not even said as Muyuka, it's said as Makala. Even in the brief of that was filed, it's referred to as Makala, which isn't a real place. So I would say that on that inconsistency on the visa is outweighed by all the other evidence. As to the second claim of inconsistency, which was Mr. Bernard Faminka not being a sibling, but being an uncle, well, the aunt filled out the application. That was only a contact person.
It had nothing to do with a brother filing for him. There was no application. There was no birth certificates or any of that stuff, which, by the way, takes 12 years. So that was sort of a non-entity. But Mr. Bernard Fomenko himself was in court. He is the one, and on the 589, he is not listed as a sibling. The one that, and the Perjurer Act, Mr. Leckie testified to. In the application itself, Mr. Leckie says repeatedly, I don't know why it says sibling. When asked, who is this person, on direct and on cross, he says immediately, he's my uncle, my mother's younger brother. So had they had Mr. Fomenko testify, a lot of this stuff that was used as somewhat credibility issues could have been completely cleared up. But the judge was in a rush. She didn't want to hear anymore. She was frustrated by the whole process. And therefore, she didn't allow Mr. Fomenko to testify, which would have been the correct thing to do, and also the thing that would have allowed the chain of custody on the photos that were used as exhibits to be discussed and heard. So the, we would say that that itself is really not an inconsistency at all, based on everything else that he personally wrote. And Mr. Fomenko's statement, and Mr. Fomenko, who she said was in court and available to testify, he was listed as a witness. He would have been able to testify. He should have been able to testify. The third inconsistency, which is the only other one listed, is that the judge goes back and forth. She says, well,
counsel, if I could ask you just on the point that you just made, was there an objection made before the IJ, or I don't recall reading any discussion about there being an error by not allowing the uncle or brother to testify? I mean, is that in your brief anywhere?
Your Honor, it isn't as a separate issue, but it is discussed that he was present in court and available to testify as a witness, and that his declaration is in the record, and therefore normally that's what an immigration judge
but
would do.
have you ever argued anywhere that was an error?
Indirectly, yes, I would say yes, Your Honor. It is both in the brief and the BIA, and also in the fact that did counsel themselves and CARE say specifically, we object? They asked to have, the judge said no. They didn't say, for the record, we object to that, if that's what you're asking, Your Honor.
But they did proffer that witness and call that witness, and it was refused, correct?
Correct, Your Honor.
So the objection stands, and if you make the motion as denied, I think there's nothing that charismatic necessary beyond that, is there? Do you know?
No, I mean, at that point, there's nothing that counsel could have done. They have to accept the ruling of the judge.
That's part of the, Ms. Beach Oswald, I guess that's part of the analysis, and we'll go back to the record and see if that's correct. But then the other half is whether or not this is an issue that you raised on appeal to the BIA and to us. And I think the answer to that question from Judge Agee was a no. Is that right?
Your Honor, I would say that it's certainly, I don't have the exact quotes, but certainly, yes, it is in the briefs that discusses that he was available. It was also in esteemed counsel's brief that he was available to testify.
It is in the brief. That could mean a lot of things. All kinds of things are in the brief. Your name is on the brief, but the question is whether or not the issue was properly raised in the brief.
The issue was raised, Your Honor, that Mr. Fomenko was available to testify, and that
the IJ made a mistake in not allowing it. Is that in the brief? Is that what you're representing to the court?
I would have to check if those exact words were used, but certainly it was discussed that he could have discussed chain of custody of the photos, and he had intimate knowledge and information that could have been helpful to the court. Your Honor, if I see I'm running out of time, if I may proceed with the third inconsistency, which is on the two assaults of Venga Prison. There were two. one in May 30th before he was arrested, and then another one in late June. The July article at J237 specifically says, in July 2018, last month, unidentified gunman stormed age-old prison in Bavenga. Last month to me means June. There was another one in May, but all parties agreed that there was one in May. As far as goes, on that particular incident, 160 inmates actually escaped. So on the corroboration of what was asked for corroboration, I think here the judge did somewhat confuse the burden of proof with credibility and corroboration. There was a lot of corroboration. There was his testimony. There was a witness there who would have been available to testify, who was his uncle. There was 2 other uncles' affidavits. There was numerous pictures of his home that had been burned down after he left. There was pictures of other things that had happened when he went to the hospital. For the judge to simply discount these family affidavits as self-serving, that is directly contravenes this court's recent case in Marie del Refugio, Arita Duras, and also Ganzami Miku. Hospitals, the record shows in the country documents that hundreds of hospitals are not functioning in dangerous areas. In fact, the nurse told him specifically to leave this country the same day, and his family picked him up. I see that my time has run out. May I just complete my thought?
Yeah, you may.
Thank you, Your Honor. The other things that the judge asked for were, he did explain, for her to ask for something from a smuggler, that's unrealistic, totally. Or some kids that helped him in the neighborhood who were paid, who just showed up for 2 hours. Or the cocoa farmer who had no electricity or phone, where he was hiding, or people he was arrested with. These are not reasonable, and he was never given an opportunity to say why he didn't provide those. The ones that he was asked, he did explain why he didn't have. Thank you, Your Honors, and we would ask that this case be remanded for further proceedings to have a full and fair hearing.
Thank you, Ms. Beach Oswald. Ms. Melnick?
May it please the court, Karen Melnick on behalf of the United States. I'd like to begin, if I could just, where the discussion with the uncle and whether or not that was raised by counsel to the board or to this court. I would represent that it was not made an issue in terms of an abuse of discretion. Certainly I would have responded to such an argument if it had been in the brief. So I would suggest that and argue that it was not made an issue regarding the uncle's testimony. And the fact that he remained in the courtroom, counsel in the courtroom, petitioner's counsel controls their evidence, and that was up to them to have him excused.
Is that a rule, a procedural rule for the hearing?
I don't know if it's a rule that immigration judge. I think, counsel knows what evidence they're going to present. And if they leave a witness in the courtroom, that's their call.
Well, that's what we normally we function by rules in terms of procedures. So there's no rule. You're just saying that you as a counsel, you would have done it different, correct?
Well, would be if I was on the other side, it'd be my burden of proof. So I would be responsible for that burden.
With respect, I just wanted to sequestering witnesses are not necessarily automatic.
It's still, if counsel intended to call that witness, then it was her responsibility to not have them in the courtroom. Again, I'm not really fully prepared to make this argument because this argument was not made to the board or to the brief. So I would suggest that it was failure to exhaust and another way, and in any event, waived.
Well, it's the reason why the board insists that I'm just, and I appreciate that you're not prepared to answer it, but in the context where a lot of this is that you're saying the judge finds that is bereft of testimony from the uncle that could have cleared it up, but then the uncle wasn't allowed to testify.
Well, it's speculation that the uncle could have cleared up everything. I would suggest that the uncle cannot clear up the fact that this petitioner, either you believe that he's a contact center telephone person in Douala, or he's a cocoa farmer in Mayuka, because the record does not compel the conclusion that he's a cocoa farmer in Mayuka during the relevant time period, because there is contradictory evidence supplied by him. And after, he tried to get into the United States, or was on the route to trying to have go through visa, and as late as May 2018 at his counselor interview, although he conveniently doesn't remember the details of that interview, and conveniently alleges that his aunt filled it out for him, although he supplied the information and didn't make any corrections to it when he was interviewed. But yet, if he's a
well, does this record reflect his level of literacy?
I don't know. It
Well,
seems that he
seems. Excuse me, counsel. Then why is it unusual that he would tell someone the information for someone else to fill it out for him if there's no record of his literacy? I mean, you say, you keep using the word conveniently, meaning, and obviously you use that in a derisive way, which you can because you're counsel, the other side. But how is that wrong? Because someone helps him fill out something. And people in this country, the United States, the richest country in the world, that don't have the means and the abilities to be able to fill out forms, and other people fill them out for them. And how do you suggest that in itself is indicative that it's not true? That's my question.
I'm not suggesting even necessarily that it's untrue that he had his aunt filled it out for him, but he acknowledges that he was the one that supplied the information. He was the one that appeared for his interview. And yet, when I would direct your honors to the record of 196 through 200, where he's cross-examined on this, I would say, case-defining inconsistency regarding where he lived and what he did for a living at the relevant time. Because if he's living in Douala as a contact center agent, then none of these events happened to him. They very well and were happening to many Anglophiles in this area of Ambazonia, this southwest region of Cameroon. But the record does not compel the conclusion that he was living there at that time, as he says. And I think the biggest sticking point, as was brought out by your colleague, is the marriage certificate in April of 2018. There's no suggestion that his aunt filled out his marriage certificate, and his marriage certificate says he was a contact person or advisor living in Douala. Yet his asylum application says from 2016 to 2018, he was a cocoa farmer living in Mayuka. Well, they both can't be true. And therefore the record does not compel the conclusion that he was a cocoa farmer living in Mayuka. With respect to the televideo and those interruptions, I think the court's Rusu opinion is instructive, although it was ultimately decided based on a lack of prejudice. The court details the factors to consider when such a problem has arisen, and whether or not there is in fact a violation or an error that needs to be, that would require remand, and a meaningful opportunity to present the claim, substantial amount of time to explain, the IJ's sincere efforts to understand the testimony, numerous opportunities to elaborate and clarify the testimony, and at bottom, whether or not the immigration judge understood the factual predicate for the asylum application. Now, as your honors know, this was not a off-the-cuff oral decision made at the time. This was an 11-page, single-spaced written decision by the immigration judge. It was, I would suggest, very clear that the immigration judge understood the factual predicate of the claim. And again, as your honors brought up, you know, to this day, what exactly, what petitioner was unable to address, what claim, what facts. Counsel did mention he was not able to testify about everything in his declaration, but the declaration was in the record and certainly considered by the immigration judge. So, and again, at the time that this happened, and I have the exact time period, the merits hearing began on page 102, and the problems arose at AR 121 and continued on and off until AR 146. So it's a section of the direct testimony. The remainder, once the petitioner was moved to another room, there were no more problems at all with the testimony. The rest of his direct, all of cross, immigration judge's questions, redirect, there was no other problems and no issue raised before the immigration judge at the time by counsel in terms of, hey, we need to just pick another day. This isn't working out. There's too many problems here. In fact, counsel asked the immigration judge if perhaps they could just submit a written statement and just be cross-examined on it and have redirect. Fortunately, that wasn't necessary. The problem was fixed and the testimony continued uninterrupted. Again, as was already brought out, that the demeanor factor to the adverse credibility was not relied upon by the immigration judge with respect to the televideo. Now, your honors, if I could direct you to AR 110, the immigration judge had already started noting before there were any problems at all with the televideo that the testimony, what was being brought out, seemed rote. And the immigration judge brought it out again at page 153, 154, that, the way it was coming out did not seem credible to him. So counsel was actually on notice at that point. And if, commonsensically, if the televideo had been a problem with the demeanor, interruptions, disjointed, this was not the demeanor finding by the immigration judge. Like, I couldn't follow it, it just seemed out of order. In fact, it was the exact opposite demeanor finding, that it seemed rehearsed.
Well, that's, it seems rehearsed. When you say things like that, what does that mean?
I think that
for example, I'm sure you're prepared. You prepare for this argument, and so somebody said, "Well, the argument seemed rehearsed." Well, it should, because I'm sure you did your work. You went over it, but that's as if that means that it's not true. When someone is nervous, for example, this is an arduous situation. All those countries he came to, it's almost like. Not you, but we look at these cases like we're talking about a picnic or something, or some primrose path. It's a long and arduous road to get you there, and you're there, and you say it sounds rehearsed. Well, maybe it is, because maybe you go through your head over and over and over because you want to try to get the facts right. That doesn't mean it's not true. When you say things like that, to me, that doesn't mean anything. What does rehearsed mean? Tell me that. We have a record. This is the only thing. What does that mean to say someone testified under oath and is seen rehearsed? What does that mean?
Well, I think in this case, the immigration judge was noting, and perhaps this was the fault of counsel as well, that the level of detail and that the language that he used in court was the exact wording in his declaration. I think that was the point that the immigration judge was trying to make. I hope you think well prepared for this argument, but every time I sort of talked about it to myself or out loud, it didn't come out the same way every time. It came out differently. I didn't memorize it.
Counsel, I'm glad that you said that, because that's the catch-22 in most of these cases. You said it very well. You said, well, it doesn't come out the same way as a declaration did, but when it doesn't, it's inconsistent. Aha, you see there? Here he said X, but there he said Y. I think so either you, one or the other, it's so important. And then go back to you're saying the final decision had nothing to do with it, but these are the judge's words, right? It described it as torture. The situation was maddening. Let's stop me when I'm not quoting her words. I can't work like this. Is that correct?
Yes, Your Honor. I think at that time, the immigration judge was extremely frustrated and worked diligently to fix the problem. And I think, as I brought out in my brief, if you note, every time there was an interruption, in order to keep a cohesive telling of his version of events, the immigration judge each time picked up exactly where he had left off and said, okay, sir, you were just telling us about X, or you were just telling us about Y. Please continue with what you were just telling us about. So in order to keep that, level of continuity, the immigration judge did, I would say, a yeoman's job of making sure that presentation, despite the interruptions for that, what amounted to 20 pages in the transcript, but a section of his direct, to keep it flowing. And again, once he was moved to another room, no problems whatsoever for the rest of the hearing. And I also, Your Honor, had brought up his many travels through many countries. I would argue that, he has no proof of that, and he couldn't keep straight what he had done with his passport. Did the military take it? That's at AR 125. Did he have it all along? That's at AR 171 through 173. Did he destroy it in Panama? That's at AR 184. And, from experience as a federal criminal attorney, we always told the jurors, the truth is easy to remember. It's the lies and the stories that are hard to keep straight. And I think that petitioner had a difficult time explaining away the inconsistencies in his testimony and his documents. And at the end of the day, the burden of proof, it cannot be overcome in this case. The record simply does not compel the conclusion that he was a cocoa farmer in Mayuca during that relevant time period. And if the record does not compel that conclusion, then the rest of his version of events just fall away.
Do you think his uncle could not have helped with that?
I don't know if his uncle could have helped him with that or not.
Exactly, but the man is sitting right there in the court, and yet that becomes the sine qua non of this. You said it very well. You said, without that, that's the crux of it. But here's someone who's sitting right there, and because and the whole idea is because he heard what he said, which I find is interesting, that the witness can come with you and been with you for 10 days, all this time, and just because magically they're not sitting in the courtroom when you testify, all of a sudden it's like night and day. It's a whole lot at stake for these cases. It just seems like it's, I suppose, something that's so important to a human being's life in terms of it's documented what's going on in the country. People with anglophones, we know that. There's no question about that. And someone makes it there, there's someone, a witness there who you now says the focal point, and you say, no, you can't testify. Well, I understand you have a duty to do to your client, represent Attorney General, but it's Interesting. Well, that's fine. Go ahead, you may proceed.
Well, again, I would have to argue that, again, I'm sort of not in a position to have perhaps a better response, because it wasn't raised to the board and it wasn't raised in the brief. So I don't think the court really has jurisdiction to decide this case based on an issue that the government didn't have an opportunity to respond to.
Counsel said it was referenced there, but
well, I would invite the court to double check that, because I think it's something that the board would have addressed, and certainly I would have addressed if it had been made a specific contention in this case. But with that, I think I've made the points I wish to make, and if there's any other questions from the panel, I would submit on my brief.
Thank you, Ms. Melnick.
Thank you.
Ms. Beach Oswald, you have some time reserved.
Thank you, Your Honor. So I think, Judge Gregory, your point about being rehearsed is leading to not being consistent. I would say that in this record, he was extremely consistent. He was consistent with his Customs and Border Patrol Q&A. He was consistent with his credible fear interview at the border, despite having gone through all these countries in enormous fatigue and exhaustion. He was consistent on his application for asylum, his 589, both in listing who was his siblings, who were his parents, what was his occupation, and when did he work at those particular places. Certainly, he did work in Douala. Douala is a real address. It's the central capital. Muyuka is a farm. In Cameroon, there is no specific addresses for people's residences. Your Honor, I would also say that the esteemed counsel referred to them as Anglophiles. That's not correct. Anglophones, because of everything that it implies, not just that they speak English, but that they're from the English zone, that they're born in this Northwest, Southwest. And right now, those people are being extremely targeted. The visa application he did not fill out. That's the only thing that the counsel for the government was able to point out, and the marriage certificate. But at the same time as the marriage certificate was done, just about a month later or before, the birth certificate of the daughter specifically says Muyuka, and they're about an hour and a half distance. So everything is declaration, and all the totality of the circumstances of other documents certainly do weigh in favor of the fact that the respondent has consistently been truthful, consistently said the same thing. He was only asked questions, he said, for about 5 minutes. I've been to consular interviews many times. That's sort of the procedure. I've also been an immigration attorney for 30 years. I've been before this particular judge many times. She's a good judge. However, in this case, I think she was extremely frustrated and rushed. And Your Honor, in my experience in 30 years, it's always the judge in immigration court who says, would you like to sequester your witnesses? That's what the judge says. And if the judge doesn't bring it up, the government brings it up. I never had that not happen.
Ms. Beach Oswald, so on that point, you had about 20 minutes, I guess, while your colleague on the other side was arguing on behalf of the government. I hope to look at your brief and or reply brief. Can you point us to where exactly that issue was preserved?
The issue of the uncle not being able to testify?
Yes, ma'am.
Your Honor?
Right.
It was not discussed as an issue per se. It did discuss.
Well, what does that mean? It either was or it wasn't.
Well, it talks about him being in court in the government's
Where?
page 9.
Where?
I would be happy to try to find that, Your Honor. I'm sorry.
Well,
I don't have it right.
I don't think it's there, is the bottom line. And you're making an argument that simply isn't preserved, and you're sort of suggesting and dancing around it, and I frankly don't appreciate that. So either it was or it wasn't.
I do see it in a footnote, Your Honor, in the government's brief. It's addressed on page 9.
The government's brief? You're relying on the government's brief?
No, We do discuss the witness, Mr. Fomenko, Your Honor. We do not say that it was a violation
Where?
of due
Tell me where it
process.
is. Where is it?
It's in the credibility section, Your Honor. You are correct in that it's not specifically referenced just as part of the totality of circumstances, Your Honor. It is in the record, however, his testimony and the
Well,
fact
you concede that if you didn't raise it in your brief, that it's waived.
I would say that it is part of the credibility issue, and it's, in all fairness, it was not raised as a separate issue. I would say that it's tangentially in there, but it is not raised as a specific issue, Your Honor. We would not agree necessarily that it's waived, though, because it is part of his credibility and totality of circumstances in the record.
All right.
Counsel, your time is moving on. This is past.
I have no further questions except, Your Honor, to say that in Russo, Mr. Leckie, who spent many months in the jungle and in the form of past persecution, and he certainly still has a well-founded fear of future persecution. This case, in the record, there is testimony also by Mr. Leckie himself. He writes the letters to his counsel saying he can't understand her because she speaks American English, and saying, you know, that she wasn't able to visit him because there was an outbreak of measles. So there was a lot of problems, as there are in many immigration cases. I personally did Mr. Fomenko's asylum application, so I'm very familiar with the fact that the family has been persecuted with his uncle. I have nothing further to say, Your Honor.
Thank you, counsel. Ms. Beach Oswald and Ms. Melnick, we can't come down and greet you as we would like to, but please know that we appreciate your argument and these very, very difficult cases. And you did a great job in presenting your prospective clients' positions. And I would hope that you would stay safe and be well. Thank you so much.
Thank you, Your Honor.
Your Honors.
Same to you.
Thank you. Let's, you want a 10-minute recess, members of the court?
Thank you. Good morning. May it please the court. I'm Virginia Bondurant Price on behalf of Overhead Door Corporation. Here, plaintiff did not offer the type of proof you typically have in a product liability case under Virginia law. She had the veneer of a product liability case. Plaintiff lacked the required evidence and experts to prove her product liability case. She resorted instead to using buzzwords and legal terms of art as a smokescreen to cover these basic failures. We ask this court to reverse and render final judgment for Overhead Door. Plaintiff proceeded on claims of negligent design through negligence and breach of implied warranty and failure to warrant. Plaintiff failed to establish her design defect claims for 3 reasons, each of which is dispositive. First, plaintiff failed to show the subject container was unreasonably dangerous for its ordinary and foreseeable use, either through an industry standard or through reasonable consumer expectations. Second, plaintiff failed to establish causation. Third, plaintiff's design expert, Dr. Singh, should have been excluded. Virginia law is clear that manufacturers are not required to make accident-proof products, and a manufacturer is not an insurer of its product safety. Rather, Virginia law requires a plaintiff to prove that a product contained a design defect that rendered it unreasonably dangerous for its ordinary or foreseeable use. And Virginia allows a plaintiff to establish that through failure to comply with the government standard, failure to comply with an industry standard, or failure to comply with reasonable consumer expectations.
Ms. Price, can I ask a question that I think is related both to the design defect issue and the proximate cause? It was conceded at trial that the crate in this case was designed in a way that it included a handhold that would be used to either lift or pull or push the crate in the normal course of work or operations. So why isn't it just so obvious, patently obvious, that if you have a crate that has a handhold that's intended to be used to be pulled, and when someone actually uses the crate in that fashion by pulling on it, and it snaps and breaks, and there appears to be no evidence that the crate was otherwise damaged or defective, although I imagine you might have some dispute about that. But why isn't that just so obvious that you don't really need an expert? It's just clear that for whatever reason, the crate didn't operate as it was intended, and that caused, unfortunately, this decedent's death.
Your Honor, here, those aren't precisely the facts of this case. It's not in the normal use of just pulling and pushing on the crate where the handle broke off. In this instance, it was stuck on forklift tines. And it's the plaintiff's burden of proof to establish that, typically through expert opinion in a product liability case, that crate...
So let me ask you, Ms. Price, about that. So it was stuck on the tines, but if it's stuck and you assume that someone is pulling on the crate, a person of normal weight and height, why does that matter in this case? I mean, if it was intended to be a handhold, it should have been shouldn't have been susceptible to somebody pulling on it and the plank breaking. Why does that matter?
Here it matters because it's plaintiff's burden of proof to show that the product was unreasonably dangerous for its ordinary and foreseeable use. And here, plaintiff tried to establish to do that through an industry standard that wasn't applicable. It was an all-wood crate without a handhold, whereas here it was a triple-ply corrugated container with a wood end crate that had a handhold. Plaintiff was obligated to show that handhold, under ordinary and foreseeable use, was unreasonably dangerous. And typically you would do that through showing that the handhold did not meet some sort of strength or pull resistance requirement. It's not in a layperson's understanding of what pull resistance a crate may or may not have. Just like any other handhold, there's going to be some sort of resistance at which it's going to fail. And it's the plaintiff's obligation to demonstrate that this particular container didn't meet the pull resistance for this particular purpose. And they didn't do that. But
I mean, isn't the pudding and the proof and the pudding and the results? It didn't, right? So why? I'm having trouble understanding that response.
Well, Your Honor, their obligation is to show that the pull resistance of the crate, or the handhold on the crate, was unreasonably defective or unreasonably dangerous for the ordinary and foreseeable use. First, they would have to show that it would be foreseeable and ordinary to pull on this crate 8 feet up in the air with a person on a ladder rung, pulling with all of his might, his entire strength in the C position, that would be an ordinary and foreseeable use. They didn't do that here. And additionally, they would have had to have shown that the handhold or the crate or the container didn't meet some sort of safety standard. And the safety standard is, under Virginia law, is established through either a government standard, an industry standard, or a reasonable consumer expectation. And here, it's not sufficient that it just, broke. Virginia law is very clear that
was there an applicable, Ms. Price, is there an applicable standard for a crate like this? I thought they were sort of one of a kind. They're produced as needed. So I'm struggling to figure out exactly what standard would have applied in this case.
Your Honor, there may not have been an exact industry standard. That's, again, plaintiff's burden of proof to come forward with an industry standard of which we failed to comply. But if there is no industry standard that's directly on point, that's where Virginia law turns to cases like Ford Motor Company versus Bartholomew, where there is no industry or government standard that's directly on point, but the expert, through his scientific engineering background, is able to point to industry norms, use testing, look at the product itself, and demonstrate what the safety standard should have been and how the defendant failed to meet that. Plaintiff didn't do that in this instance, and it's not...
Counsel, didn't Dr. Singh do that? He said that if you want to have something where you expect to be pulled but with 200 pounds, if you do that, you'd have to have the cleats and those kind of things. That's exactly what he was just saying. Because he didn't have an industry standard, never said it, 30 or 39 wide here, but he said that you have to do these kind of things if you're going to do that. But your client didn't test it at all for safety. Really, did it?
Respectfully, Your Honor, what Dr. Singh said was, at first he said D6039 was the applicable standard, and then he walks away from that when he's frankly questioned by the district court about that. He then turns and says, okay, you can design a container distinct from, with different characteristics than the D6039, but then you'd have to test it. And he did not go on to say what kind of tests you would have to do. He vaguely described ASTM 4169. He vaguely described pull resistance standards that you could use to test the handhold, but he doesn't say that he did those or that this container failed to meet those testing. Importantly, Virginia law requires that you prove a product to be unreasonably dangerous through a defect in manufacture, design, or failure to warn. It does not allow a standalone failure to test. And so Dr. Singh simply pointing and saying, oh, well, you can deviate, but then you'd have to test it, and they didn't test, doesn't demonstrate a defect in this instance, because it doesn't establish that it's unreasonably dangerous for the ordinary or foreseeable use. And even if you accept a failure to test here, Dr. Singh didn't go on to say what that test would have been or how overhead door failed to meet that test.
Ms. Price, isn't part of the problem here, though, is that, first of all, the original crate or box wasn't preserved, right? So we know you couldn't test that. And because these are one-of-a-kind boxes, maybe you can help me on this. It either wasn't clear whether or not your client could actually produce one, or it may have been that the plaintiff was concerned about whether or not that the one that they might produce as an exemplar might not actually match up with the exact contours and dimensions and properties and characteristics of the box in question. So wasn't the plaintiff in a bit of a difficult position here?
No, Your Honor, they were not in a difficult position here. They asked for a box during discovery. You're right, through no fault of the parties, the box was discarded after the accident. So the exact subject box or container was not preserved. But plaintiffs asked in discovery for Overhead Door to produce an exemplar. And at first, Overhead Door declined, and that is a discovery response dated April of 2018. Plaintiffs sat on their laurels, so to speak. Their expert report through Dr. Singh was, his first expert report was signed on September of 2018. It's not until July of 2019 that plaintiffs bring up this discovery issue. They didn't move to compel an exemplar box. They didn't do anything except on the eve of trial, they filed a motion in limine to prevent us from asking why Dr. Singh didn't test. But in actuality, we did offer during that time period to make them an exemplar box. And they declined because they said that we would make some sort of super box. So this was really a discovery issue that they're now trying to make a part of their case, both at trial and then now on appeal, by excusing their lack of testing in this case by saying they didn't have an exemplar box. And one other point, Judge Diaz, is that they knew how this box was made. They knew what size nails we had. They knew what kind of lumber we used, what size lumber. They could have made the box themselves. So Dr. Singh walks away from his D6039, saying that this is not the applicable standard. The district court recognized that D6039 was not the applicable standard, saying when comparing D6039 to the subject.
Ms. Price, can I go back to the issue of, proximate cause, because that is a question I think Mr. Emmert needs to answer as well. So if I understand you correctly, the issue with proximate cause is that because there was no baseline by which the box, there was no established baseline with respect to any pull resistance, however you want to call it, that it's just impossible to prove that any possible defect in the box was the proximate cause, because we don't know exactly how much pull resistance the box was intended to withstand, and we don't know whether or not the box was damaged either as a result of the operations on that day or beforehand. Is that right, or is it more than that?
I would just correct a few things, Judge Diaz, on our position. So the first is on the but-for causation. On the but-for causation, Dr. Singh never gets them to their requirement on their burden of proof on but-for. And the reason for that is because he cannot show that but for the absence of the exterior end cleats, which is what Dr. Singh says is the design defect of our box, the absence of end cleats, exterior end cleats, I should say, that Mr. Sardis's injury would not have happened. And it's not impossible to discern how much pull resistance Mr. Sardis would have put onto that box. It's essentially a math equation that an expert could do, knowing Mr. Sardis's weight and height, and then knowing how much resistance he could have put on that. They could have done that testing. They could have gotten an exemplar box. They could have pulled on the box and seen what the pull resistance was of the subject container that had interior end cleats but did not have exterior end cleats. They could have then seen if the pull resistance that Mr. Sardis likely would have put on the end of that box would have sustained him pulling on it. And then likewise, putting the exterior end cleats onto the end of the box and testing it that way. That's precisely what they should have done here, and they failed to do it, and they therefore did not establish but-for causation. As to our other proximate causation argument, they cannot establish proximate cause in this case without the slat, without the missing slat. So there are pictures of the container itself. There's also testimony that just before Mr. Sardis's injury, the container was taken end over end before it was put up on top 8 feet on the rack. No one is able to testify, including Mr. Lawrence, including Dr. Singh, what the condition of the slat was. Without the condition of the slat, there's no way to know if it pulled off due to some issue. It got, loosened up going end over end, or and the fact that it sat in the warehouse for 2 weeks, Mr. Lawrence testified and Dr. Singh testified that it didn't look like the container itself had any damage, but no one was able to identify whether there was any damage to the slats. And that's our other proximate cause. Without knowing the condition of the slat, they cannot say whether or not the slat pulled off because of damage to it or some other reason.
Your position is if the box is gone, as here, it was gone right after the accident, then no plaintiff could ever prevail in any case like that.
Judge Gregory, respectfully, that's not our opinion.
Isn't that the result of what you just said? You said without knowing that, you said without being able to inspect the slats, you can't prevail in proximate cause. Didn't you say that?
If I did, Your Honor, I apologize, but
no,
I think
I'll take it for your word. You didn't. But tell me, what is your position about not being able to determine what it looked like? Go ahead.
Sure. So I think the distinction that I'm making is there's under Virginia law, my argument is not that a plaintiff could never establish a product defect with a missing product. And I see that my time has expired.
No, go ahead. I want to ask you the question. Go ahead.
Sure. It's not that a plaintiff can never establish a product liability case without the product. The distinction is that when the essential piece of evidence, like the slat, is missing, you cannot rule out other potential causes of why that slat pulled off. This is like the Stokes case with the saw, and how the saw had been stored away, and there was a question of whether it had been improperly stored such that one of the component pieces was damaged, and that resulted in Mr. Stokes' eye injury. And that's what we're saying this case is like. With the physical evidence of it being stored for 2 weeks, not knowing the condition of the slat, the fact that it had been taken end over end directly on those slats, that there is a distinct possibility that it could have pulled off for some other reason, like it being damaged. And that plaintiffs in a case where there's a missing product would have to rule that out in order to establish proximate causation.
Well, that's what I just said. Basically, that formula, it means you can't prevail because you said there would always be speculation as to the possibility that something else happened to it because you don't have it, correct?
Well, Your Honor, if there's a missing product and there's no other potential proximate causation, then you would not need the product in that instance.
That's what this case might be. That is, you don't need it because you told them to hold on to it, to pull it around and everything. That's exactly that's the consumer expectation, isn't it? It's like carrying a bag. It's a bowling ball bag. And you pick it up and the ball, it falls and the ball, breaks your toe, you get a broken toe. You say, well, you can't recover because we don't know how much pressure it is that it should be able to carry a ball or not. Well, the handle broke.
Well, respectfully, Your Honor, in that analogy, the bowling ball bag carrier is designed to carry the bowling ball. What plaintiffs have not established here is that the ordinary and foreseeable use of the product was to pull on it with all of your might in the C position, 8 feet in the air, while the container is stuck on forklift tines.
Well, can I suggest something that your client didn't say that it could not withstand a 6'5" male weighing 300 pounds pulling on it, did it? It didn't there was no parameters at all. It's just that a human being could pull on it, and it weighs 200. So in terms of resistance, I mean, it's just like the bowling ball. I should be able to pull on it. Someone at 5'5" and someone who's 6'5".
Well, respectfully, Your Honor, that goes to a little bit of our failure to warn cause of action. And on that issue, it goes to notice, whether or not Overhead Door was ever put on notice regarding whether it knew or should have known that users were using this 8 feet in the air, pulling on it 8 feet in the air while it was stuck on forklift tines, and he was pulling with all of his might. And that is something that they did not show, and that's part of the reason they also failed to establish their failure to warn claim.
Well, your 30B6 definition said you never even considered safety or danger at all. Something like that, you never considered any, that's what it said, correct?
Well, the 30B6 witness did testify about some generalized safety standards and issues, but what the failure to warn requires, and their burden of proof on that, is not to establish some generalized safety issue. They have to prove knew or had reason to know about the specific risk. And the specific risk here would be that somebody was pulling on the handhold 8 feet in the air while it was stuck on forklift tines with all of his might, and that the handle would break. And they had no evidence that Overhead Door had any notice of either of that.
So, Ms. Price, if the crate had been on the floor, and in fact, this happened apparently according to some, it wasn't in the record testimony, but the person who was working with the decedent that day, either a deposition or somewhere, testified that he had pulled the crate along a floor and it had snapped and he'd fallen backwards and landed on his rear end. But if that had happened to the decedent in this case, and he again had hit his head and suffered some injury, maybe not death and something less, at that point, you no longer have the argument right about the particular conditions, but I suppose you still might have an argument about the condition of the box before it was handled by that person. Is that fair?
That's fair, Judge Diaz. But one other thing that I would add is that testimony came from the court. It was not competent testimony that was before the jury to which they could consider. And part of the reason that it was not before the jury was, one, it was not substantially similar to the facts that we have here, so the district court had excluded it. But the other, almost more important reason is that Overhead Door never had notice of that incident, or those 3 incidents, as you will. They only were provided to Washington Overhead Door, which is not the same thing as Overhead Door. Overhead Door never had notice of those 3 incidents.
Yeah, no, I understand that, but notwithstanding that, all that stuff came in front of the jury, and I don't imagine that was helpful. But in any event,
I see that I'm very much over time. I'm happy to answer more questions or see you again on rebuttal.
Thank you, Ms. Price. Mr. Emmert.
Good morning. I'm Steve Emmert, and I represent Andrea Sardis, who is the personal representative of her late husband's estate. This oral argument convinces me that von Moltke was right when he said that no plan of battle survives first contact with the enemy. I have a really nice speech here, but what I've just seen in the last 15 minutes or so convinces me that I need to start by going for the jugular of this, and that's by establishing that if Overhead Door is correct about this, and that standards don't apply as long as you're able to, I'll call it, dumb down one of the components, then imagine what happens with products liability cases. Every manufacturer will be free, if they wish, to evade well-established, well-researched, and consensus standards of the industry by simply making a product a little bit less or not meeting one standard. Overhead Door in this situation could make a crate out of paper mache and then claim that we don't have to meet D6039 because we don't have a thing that meets the crate. The definition—
Mr. Emmert, if I could ask kind of a threshold question here that opposing counsel didn't address this in opening argument, but did raise it on brief. It appears that with respect to the design defect claim, Dr. Singh responded to Judge Gibney when asked, after Judge Gibney had described the crate or box in this case, whether that standard applied. And as I read the record at 539, he says no, that it didn't, but you'd still have to test, but never identified a particular testing standard or whether or not a box of that type would meet the standard. So to me, that raises a threshold Daubert question here. I looked at the initial ruling of the district court before trial, which to say that it's brief is maybe to give it too much credit. Even though it acknowledges that there were legitimate questions raised about the expert witnesses, the district court simply says, well, you know, that's for the jury to figure out using cross-examination. But under our Daubert precedent, the trial court has an initial gatekeeping function to assure that the expert witness's testimony is reliable and it's relevant when it's submitted to the jury. And it looks like in this case that the district court simply abandoned its gatekeeping function. So how do you answer that? I mean, how can the case go forward if the trial court simply says, well, you know, my Daubert gatekeeping function, I'm now ceding to the jury to determine based on cross-examination?
The way I read the record is not as dismissive of what the district court did in this case as what Your Honor suggested. The court didn't simply say, I'm going to let the jury decide the Daubert issue. Indeed, the court reviewed the credentials of all the experts, ours and theirs, reviewed the background of the literature and the depositions and the other physical evidence that the experts considered, and decided that the expert had the capacity to offer an opinion on these things. In addition, the primary negligence in this case is not so much whether the end cleats are on there. The primary negligence is the presence of a handhold, because, and this relates to the proximate cause issue as well. If there's no handhold there, there's nothing for Angelo Sardis to be pulling on, and the crate doesn't fail.
So, but Mr. Emmert, if I'm looking at pages 287 and 289 of the joint appendix, which is the Daubert ruling, where do I find any of that?
I don't think that you're going to find that the judge specifically lays out what I've just ruled, or what I've just not ruled, what I've just suggested to you. What I will say is that the judge had all this to consider and found that there was an adequate foundation for the experts to offer an opinion on these things. Not that the expert had a particularized standard that would have applied otherwise. We think that the standard that applies is 6039. Both
right. I understand your argument, but what I'm asking you is, where does the trial court do that? Because I don't think that our Daubert precedent allows us to assume the trial court went through the litany of things you've described. We look for some sort of record evidence that it actually did it and said that.
Okay, I don't have an answer for you right now. If you would permit me, I'd be happy to submit a letter to the courtroom clerk within 3 hours at the end of this argument that will address that, if I may. Is that permissible?
Well, I mean, do you think it's somewhere other than pages 287 and 289? I mean, that's the trial court's Daubert ruling.
I don't know, Your Honor, and I'm not going to guess right here today and possibly get it wrong.
The counsel, I suppose the only response might be, the court is not obligated to give a long discourse of it. It can rule on it. The question is there evidence in the record that would support the finding? And I think that's what you were saying. Evidence that was there, whether or not, in fact.
Vastly better phrase than my answer. But yes, I don't think that a court has to lay out a litany of details as to what constitutes the background of the Daubert ruling. There's no doubt that if there had been no, as I just mentioned with regard to proximate causation, if there had been no handhold, there's no accident, there's no injury.
Mr. Ember, can I ask you about that? So that's literally true, I suppose, that if there had been no handhold, there'd be no accident in this case. But I don't think it's fair to say that simply because a box has a handhold that makes it per se defective. I mean, the question is, did the company, when deciding to include a handhold as part of the design of this box, account for the particular circumstances of how these boxes would be manipulated or used during the course of normal operations? And so that would presumably require some level of understanding of how much pressure a worker might put on the box during the normal course of operations. Of course, your colleague on the other side says that this particular day, these workers were operating under very abnormal conditions in the sense that the box was up 8 feet, it was on tines, all of that business. But I don't think it's right to say that because of a handhold that that's the end of the story. Maybe you can elucidate on that.
The position that our expert took and that we continue to take here is that if you meet the standard, you've got a presumptively safe product. That's why the standards exist.
Well, but the standard in this case didn't include a handhold, right?
Right. And the fact that that it doesn't comply with the standard doesn't mean that the standard doesn't apply. It means it doesn't meet the standard, and therefore it's not presumptively safe. In that case, both experts, theirs and ours, concluded that if you're going to vary from the terms of the standard, you have to test it. You have to test it first before you send it out into the stream of commerce. That's what Mr. White said. That's what Mr. Singh said. The testing is essential if you don't rely upon the already well-vetted standard that's in ASTM D6039. So that's what happened here. They decided they were going to go and, as I called it before, dumb down the product and not meet the standard, and then claim that the standard doesn't apply. That's not what it says. The standard contains a
Well, Mr. Emmert, is it your position that this 639 standard applied or didn't apply?
I think it does apply. It applies whenever there is a container with structural framework fastened together to form a rigid structure. That's the definition of it.
Well, how do you explain Dr. Singh's answer to the district court at JA 539? It wouldn't be governed by 6039.
I think that it's inconsistent with other answers that he gave to other questions when he said that it does apply. And the jury has to decide which one of those two is correct. But there's no question that it meets the definition of a crate. The only thing that they did was they took down some of the safety requirements. They took down is the wrong phrase. They failed to adhere to some of the safety requirements that this standard incorporates based on extensive testing. And Dr. Singh,
but if an expert witness testifies on both sides of the answer and basically says yes it does and no it doesn't, why is it up to the jury when it's your witness to decide which of the two stories is correct? If they're choosing between two opposing experts, they certainly do that all the time. But you can't rise above your own evidence. And when your own evidence is contradictory, how is the jury supposed to do that?
I'm not going to be able to pinpoint it right now and this second in answering it, but where there is a quote, a citation in our brief that says that when there is contradictory evidence, even from a single witness, it's up to the jury to decide which to accept. That doesn't mean the evidence is inadmissible or that it's thrown out. It means that the jury has to resolve inconsistencies in the testimony. And in the jury instruction, the charge, the jury is told you can believe the testimony of a witness or even part of the testimony of a witness. That's consistent with what that doctrine says. But a jury has to make up its mind about that. But fundamentally, we do believe that the standard did apply. There's no question this is a crate. And the only question is, can Overhead Door decide to ignore the safety standards contained in the standard in order to create something else that is immune from any of these safety standards? We already know that we don't have the crate here, but we do have something that's just as good as meeting a safety standard, and that is consumer expectations. The Alevroma Heroes doctrine holds that I can win a case like this in three ways: showing industry government safety standards by testimony of competent expert witnesses, or by establishing consumer expectations. And consumer expectations can come from published literature, or it can come from positive testimony about what consumers expect. We have both. As far as the positive testimony, it's the most compelling form, and that's Overhead Door's admission from Mr. Knable, its corporate designee under Rule 30b-6, who said, yes, a reasonable consumer pulling on this can reasonably expect that it'll hold up. We also have the literature. If you don't accept D6039 for some reason, I hope you will, but you still have the handbook of paper and wood products. That is a paper, that's a published literature, and that's under the Alevroma Heroes doctrine, page 420 and 421 of that opinion, I think. You'll find that that's satisfactory proof of what consumer expectations are.
Mr. Emmert, can I, so let's assume that you're right and that's a reasonable consumer expectation, but your colleague on the other side says there are two components of this proximate cause question. One is the but-for causation, and the other one is the question as to what the condition of the box was on the day in question, and whether or not there was something that intervened that perhaps weakened the structural integrity of the box. So what's your response to that?
They're asking the court to decide based upon an imaginary defect that there was no evidence of. Keith Lawrence, who was handling the box on the same day, right alongside Angelo Sardis, testified that he saw nothing wrong with it. He was there looking at it and physically handling the box, and said there wasn't anything wrong with it. The jury was entitled to credit that and find that he was telling the truth. But as for imagining a possible defect and saying we have to disprove a negative, I don't know how we're going to be able to do that when we don't have to face that problem. We do have positive testimony that the box was undamaged. Imagining a possible defect isn't the way for a manufacturer to defeat a claim like this. As far as the proximate cause issue is concerned, I do want to mention, because I think it's fair for me to do this, that Dr. Singh was able to testify to a direct question: do you have an opinion to a reasonable degree of probability that the defects in this box that you've testified to approximately caused the injury? And without objection, he said yes. He said that it did. Now, we raised that as a waiver issue in our brief, and Overhead Door has argued in reply that it twice objected, once in a motion in limine and once in a motion to strike later in the case. The motion to strike later in the case doesn't excuse the need under Rule 103 to object in a timely
Mr. Emmer, sorry to interrupt again, but you said, did I hear you correctly? You said defects as in plural in the box?
Well, there are two defects. It has a handle,
okay,
and
right.
It doesn't include exterior cleats that would have secured the exterior. But those are the defects that he found. But yes, you did hear me correct. There are two. As far as the motion to strike is concerned, that's too late under Rule 103. They have to object before the witness gives the answer. You can't go back and say, Your Honor, that question 20 minutes ago I meant to object to, and I need to object to it now. As far as the motion in limine is concerned, when I saw that in their reply brief, I checked the district court's record. I checked the motion that they made, I checked the transcript of the hearing, and I checked the district court's ruling, that I assume that you've done. And I found that they did not object to this question in that motion in limine. The motion in limine was directed to an opinion as to the mechanism of the crate's failure, not to the proximate cause of the injury. So in that sense, there has been no contemporaneous objection. If the court is permitted to, if a litigant is permitted to evade this requirement, then you're going to be much more like a trial court in evaluating these objections. The opinion that Dr. Singh was allowed to give without objection meets the preponderance standard, and this was a jury issue. There are three issues on which the simplest path for you to affirm this judgment can be laid out. First, it's an unreasonably dangerous product. We've got an admission from their corporate designee about consumer expectations. We've also got product literature. Even if you don't accept the testimony of experts, you have that much, and that makes it a jury issue. Second, on the first material breach, that too plainly is a jury issue, and the jury was allowed to decide whether a company that has safety as a core value, a core company value, and that knew that people could be killed or injured when their products failed, would do something about safety. Indeed, Overhead Door at trial pressed this issue by trying to prove to a jury that Mr. Sardis was contributorily negligent. They urged that if he had only handled the product safely, that he would still be here. But this is the safety information that they refused to provide anybody, and the jury could easily.
Well, Mr. Emmer, so with respect to that, and I'm not, this really doesn't go to issue of contributory negligence, but the question of how the box was used on that day, does that matter at all? I mean, the fact that it was where it was, 8 feet above in the air, stuck under these tines, there were some ladders below it, so it might have been stuck there too. What about all of that? I mean, that doesn't seem like to me to be the typical use of the box.
Logan versus Montgomery Ward says that a manufacturer has to make it safe for its expected uses, I think anticipated uses, and for all reasonably anticipated misuses. So even if they're claiming that it's a misuse, there's no assertion here that nobody could possibly assume that anybody would do it while it's on a forklift. I think that the location of the manipulation of the truck, of the crate, doesn't make a difference in this analysis. The question is, was it designed in such a way that it was unreasonably dangerous? We have testimony about that. On the issue of proximate causation, as I've indicated, the objection is waived. you can decide the appeal on these three issues alone, because that's enough with the special jury interrogatories for us to do that. In this case, the law doesn't allow a manufacturer to skimp on safety, to make the consumer bear the risk of failing to meet standards, of failing to provide a safe product, failing to test it to make sure of it. But that's what happened in this case. Overhead door allowed, unfortunately, Mr. Sardis to be the test for whether that was a safe product. And he paid for it with his life while using the product in exactly the way that the manufacturer had intended.
Okay. Thank you. Ms. Price, you have some time reserved.
Apologies, I was on mute. I first want to address the causation waiver argument. We cited in our reply brief on page 17 of our reply brief, not to a motion in limine, as Mr. Emmert alluded to, but actually to our Daubert motion. We moved on causation with Dr. Singh in our Daubert motion, and so it is properly preserved on that. As to,
you said in your reply brief.
I'm sorry, Your Honor?
You say you raised it in your reply brief?
Yes, sir. On page 17 in our reply brief, we responded to the waiver issue by pointing to the objection that we made to Dr. Singh's causation arguments in our Daubert motion pre-trial.
And you didn't, so you didn't, in the opening brief, you did not refer to it, did you? That is one of our issues presented in our opening brief, the but-for causation argument. Yes, sir. Okay.
As to Mr. Emmert's argument on testifying to the ultimate issue, the Stokes case is clear that an expert cannot base his answer on an ultimate issue on an insufficient factual basis, which is our argument on but-for causation, is that Dr. Singh did not have a factual basis to support that argument. And so it's both insufficient and never should have been admitted under Daubert.
What factual issue is that he couldn't opine on?
To the ultimate issue, when he was asked directly whether or not the lack of exterior end cleats was the proximate cause of Mr. Sardis's injury, he did not have the factual basis to support that answer, which was yes.
You object to that?
It was not objected to, Your Honor.
Oh, okay.
Other than in our Daubert motion pre-trial, but it was not objected to as a question at trial.
As an answer at trial?
As a question and answer at trial, yes, sir. Right.
So, counsel, I'm a little confused. Are you saying, with respect to Dr. Singh's testimony on the ultimate issue of proximate causation, you did or didn't make an objection?
We moved pre-trial and a Daubert motion on his entire causation opinion, and well, on him totally on Daubert, but including his causation argument. When he was asked the ultimate issue at trial, the question was, were the lack of exterior end cleats the proximate cause of Mr. Sardis's injury or something along that line? And the answer was yes. That specific question was not objected to. We've raised the issue also in our Rule 50B motion, and then now obviously on appeal.
Yeah, but you didn't move to strike the response at the time either, correct?
Not at the time that the question was asked, no, sir. Judge Agee, to answer your question on the district court's performance of the gatekeeper, he did not perform that function. That's part of our argument on appeal, and that can be found at JA 1179 through 1181, which is his final opinion on the case, where he was he basically gave the jury, dictated to the jury his gatekeeping function, which was to decide which of the one expert's opinions he wanted to believe, which that's the role of the district court.
Well, counsel, that would have seemed like to me to have been your threshold argument, because if there's a Daubert failing, how can it go forward to the jury? other than mentioned in your brief, you don't seem to be particularly excited by that particular line of argument.
And I see that my time's expired, Your Honor. I'm happy to answer his question.
You may answer.
Thank you. I think part of the Daubert analysis is what we led off with, Your Honor, which is the lack of standards applying. That was a threshold question that the trial court had to determine, and a basis of which to exclude Dr. Singh. We ask respectfully for the court.
Ms. Price, before you, I'm sorry, not so soon.
No
so that the standard issue obviously is important, but Mr. Emmert made a couple of points about the causation issue, which I want to tease out with you. The first one was that you're essentially requiring the plaintiff in this case to sort of account for each minute and every hour of the day of a product from the day it leaves your client's warehouse to the day it shows up at the work site in order to disprove a negative, as he put it. So that's point number one. And then he also mentioned that your client's representative at the 30B6 deposition essentially said that agreed with the notion that a consumer would reasonably expect that if he or she pulled on the slat that it would hold. And that, that seems to me just to be correct as a matter of common sense. So I don't, standard or not, why isn't there a problem here with respect to the design of this product?
Under Virginia law, and I'll address the reasonable consumer aspect first, Your Honor. Under Virginia law, plaintiffs have the burden of proof to establish that the product was unreasonably dangerous in its ordinary and foreseeable use. And there are three ways that you can do that.
Okay, so let me stop you there, and I'm sorry to interrupt, but Mr. Emmett mentioned that your client would also have an obligation to protect against misuse. Is he right about that?
No, not just misuse. It would have to be foreseeable. The standard is ordinary use or foreseeable use, which would include foreseeable misuse in some instances. Here, it's not foreseeable that somebody would use this container in the way that Mr. Sardis did. Not all handles are accident-proof. Not all products are accident-proof. That's not the law in Virginia. An analogy would be taking a banker's box, for instance. We're all familiar with banker's boxes. We all use them almost routinely. Some people store them up high on bookshelves. They're cardboard boxes. There's no warning on them not to pull in a specific way. If I went back downstairs into my file room and I climbed up on a ladder 6 feet in the air and I grabbed a hold of an extremely heavy banker's box and it was stuck and I pulled on it as hard as I could and it ripped, that's not a foreseeable use, an ordinary foreseeable use of the banker's box to pull on it with all of your might when it's stuck on something, particularly when you're that high in the air. It's a tragic event that happened with Mr. Sardis, but it's a tragic accident, a freak accident, if you will, for lack of a better term, but it's not something that Overhead Door knew or had reason to know about or anticipated that someone would use their handhold in that particular fashion. So in this instance, it was not a foreseeable use. And to answer your question on the reasonable consumer expectation, that has to be cabined, and it cannot be just, a reasonable consumer and you point to a generic statement by the corporate representative that its products are generally safe. What Mr. Knable testified to was that you can reasonably expect the handhold to hold. He did not testify and provide any sort of roadmap for what that safety standard would have to be for the handhold to hold. If I had a locked car and I was pulling on my door handle and I was pulling on it and it wasn't opening and I decided to, get down in the seat position and pull as hard as I could, or put my leg up on the car and use my leg as leverage to try and open that door handle is gonna break too. Is that a foreseeable use of the door handle? Is it foreseeable with the banker's box? These are questions that the plaintiff had to answer and failed to answer, and Knable just doesn't get him there with his generic statement. We'd ask the court to reverse and enter final judgment for overhead doors. But thank you very much for your time.
Ms. Price?
Yes, Chief Judge.
Do you agree that the consumer expectation is I can pull on this handle as much as I have strength to do so?
I'm sorry.
Is it a reasonable consumer expectation that I can pull on this crate with as much power or strength that I have as an individual?
No, sir.
Why not?
Because there's the standard in Virginia is that it has to be the plaintiff has to establish that it's unreasonably dangerous for its ordinary or foreseeable use. And
that's what I'm asking you, counsel. I'm not talking about Virginia standard. I'm talking about consumer use. Would a consumer assume that I can pull on it with what level of strength I have as an individual, not using a mechanism, but my individual strength? Don't you think that's within the realm of the consumer expectation?
No, sir.
Why not? Everybody who uses it, some people who are going to pull on it can't pick up 100 pounds. Some people who will pull on it can pick up 250 pounds. So why wouldn't it be within the reasonable consumer's expectation that I can pull on it with whatever strength I have as an individual? Now, different if you use a mechanical device, like I'm going to take a machine and pull on it. But why wouldn't that not be in the realm of the consumer expectation?
Respectfully, Your Honor, I think that your example answers that question. Under Virginia law, they have to establish a safety standard. And the safety standard has to have some sort of objective measurement. And this particular handhold, they had to demonstrate that it was unreasonably dangerous because the pull resistance wasn't sufficient. And they didn't do that here. And their reasonable consumer expectation doesn't get them there.
Look, okay, I know I'm not getting far with the physics, but if it's stuck on the forklift, do you agree that you can't pull on it more than your individual strength? That the pull does not increase because it's stuck on something. You still can't pull any more than you can pull on it. You agree with that?
I'm not an engineer, and I don't.
I'm not an engineer,
but I would respectfully disagree with that. When it's stuck and it can't move, and when you're pulling on the handle, when it's unstuck, it actually moves with you. When it's stuck and you're pulling on it, you are able to exert additional pull force on it, and that's the point.
That force, what's the source of the force when you pull on it?
That's what the plaintiff's
No, it's not a trick question. No matter how hard you pull on it, what is the source of the pull?
The source of the pull is the person pulling on it.
Right, that's the consumer. That's the point. It's you assume that you walk up there, I can pull on this with all the might that I can muster to get it through. And that's the whole point of it. That would be in the consumer. I would say, want to see, whoa, I don't know, I better not pull on this thing because I bench pressed 250 last night. I better not pull on it. The consumer has to have that kind of, it's kind of strange, isn't it? You put a handle on something. And matter of fact, don't these crates that you can sometimes contain up to 4,000 pounds or something?
No, sir, I don't believe that the record supports that. I think that's for a garage door. That's
a garage door. But this crate, what's the maximum capacity for the content?
Your Honor, truth be told, I don't remember off the top of my head, and I don't want to guess. I know it's in the record somewhere, and I'm happy to get that for you. I can guess, but I don't feel comfortable guessing. But
what's your
pardon?
Guess? What's your guess? I mean, you're supposed to know the record. What's your guess?
I think that the record would support up to 300 pounds, maybe 500. I can't remember if it's somewhere within that range.
In a crate that you're allowed to pull on it by hand, right?
Yes, sir.
Thank you. Unless you have some. Go
But
ahead.
the last thing that I'll say respectfully, Your Honor, is that, the reason that Virginia allows you to establish unreasonably dangerous through these three mechanisms, government standards, industry standards, and reasonable consumer expectations, is so that manufacturers understand what the safety standard has to be.
I understand completely. I think it's very clear. I think it's clear how they designed the crate and what capacity is. Like you said, up to 300 pounds. It takes a whole lot of human exertion. Allow you to pull a whole lot on that. But go ahead.
I'm happy to answer any other questions. I appreciate your time this morning.
Thank you so much, Ms. Price. And Mr. Emmett, thank you so much for your arguments. We can't come down and greet you, but know that we very much appreciate your being here. Hope that you will continue to be safe and well. Take care. Bye-bye.
Your courtesy to us, Your Honor.
Nepper?
Yes. Yes, Your Honor. John Nepper.
Nepper, yes.
May it please the court. My name is John Nepper, and I represent the North Carolina State Health Plan for teachers and state employees. The decision whether to demand a waiver of a state's sovereign immunity as a condition of federal funds is for Congress alone. Congress must demand the waiver, and it must do so clearly in the text of the relevant statute. The private plaintiffs in this case, the appellees, have brought suit against the state of North Carolina under the Affordable Care Act. Because that statute does not refer to suits or relief against states or to sovereign immunity at all, Congress has not demanded a waiver of sovereign immunity unequivocally as a condition of receipt of those federal funds. As the U.S. Supreme Court noted in Sosamon v. Texas, clear statement rules are not simply interpretive guidelines. The requirement of a clear statement in the text of the statute ensures that Congress has specifically considered state sovereign immunity and has intentionally legislated on it. This clear statement rule avoids circumstances where, such as the one presented here, where Congress might legislate on a sensitive topic inadvertently or without due deliberation through broad or general language. Without such a clear statement from Congress and notice to the states, federal courts may not step in and abrogate state sovereign immunity. The question for this court is whether Congress did consider the state's sovereign immunity and demand a waiver as a condition of funding within the Affordable Care Act, including for enforcement of Section 1557. The question is not whether Congress would have wanted a demand to demand a waiver of sovereign immunity. There can be no waiver of state sovereign immunity unequivocally expressed in the text of the relevant statute when the statute that provides the funding and the cause of action does not mention suits against states or sovereign immunity at all. As noted in the reply brief, the stringent standard one court's referred to as must be as clear as is the summer's sun. And where you have the judicial branch coming in and concluding that, oh, this is sufficiently similar, or we think this is what Congress would have meant, while that's an acceptable means of statutory interpretation in most contexts, in the context of sovereign immunity due to the intrinsic federalism value that sovereign immunity preserves, that's too much. And so the state's position is that there can be no waiver of sovereign immunity for enforcement of Section 1557 against the state of North Carolina or against the other 49 states. That doesn't mean that Section 1557 is a dead letter at all. There are thousands of potential defendants for which a private suit would be authorized. It simply is that there is no waiver of sovereign immunity to allow the federal courts to hear a claim brought by private plaintiffs against the state of North Carolina.
And your position is that's because the waiver of sovereign immunity is not in 1557?
Your Honor, the Supreme Court has said the text of the relevant statute, and our position is that the relevant statute is the one that provides the funding and that provides the cause of action. And neither of those are, and that is section 1557. The plaintiffs have brought other claims.
I just want to make sure you're saying because it's not contained solely in 1557, that's the reason why there's no sovereign immunity.
Well, yes, Your Honor, because there is no reference whatsoever to state sovereign immunity or suits against states in section 1557 or anywhere else in the Affordable Care Act.
Or anywhere else where you trailed off?
In the Affordable Care Act itself, Your Honor. In other words, there's no reference to sovereign immunity anywhere within the 2010 Affordable Care Act, that 1,000-page statute.
Yeah, but it references...
Well, counsel...
go ahead, Judge Agee, go ahead.
No, counsel, I think the district court agreed with you there and rested its opinion on this residual clause from a 1986 statute. So you should probably move to address that at some point, because that's the basis, as I understand the record, of the district court's ruling.
Sure. Your Honor, the district court's error was in substituting its judgment for that of Congress. In other words, the question is not whether Congress thought that this statute, section 1557 of the Affordable Care Act, was one of the statutes covered by the residual clause from 1986. It's not whether we might conclude after the fact that this is what Congress would have meant. And so, the notion that a court would have to say, well, this is sufficiently similar, which was the language that the district court used, that is not sufficient within the context of state sovereign immunity to find a waiver. Because it would be a different case if, as this court decided in Lippman, there's a specific reference to Title IX in both the Affordable Care, both Title IX and the waiver provision residual clause, or if Section 1557 specifically reached out and referenced the residual clause. But
Mr. Knepper, can I ask a follow-up to Judge Agee's question about the residual clause? So, as I understand it, part of the district court's analysis with respect to sufficiently similar is a nod to those cases where plaintiffs were attempting to fit a square peg in a round hole by trying to analogize to statutes like ARLUPA and others that simply just didn't fit within the rubric of statutes that were intended to fight discrimination. But the ACCA has an explicit provision in it, and the residual clause basically says that it applies, that sovereign immunity will be waived for any other federal statute prohibiting discrimination by recipients of federal financial assistance. I don't know, short of doing what you seem to suggest, that is including the language directly in the statute, I don't know how much more clearer Congress could have been in terms of what it intended, because otherwise, what work is that residual clause doing?
Well, I mean, first of all, I think that the clear statement rule, and specifically the Supreme Court's requirement that it has to be in the text of the relevant statute. In other words, that's not a gloss that I'm adding. That's Sosamon's explicit requirement, and it had the residual clause in front of it. I think let's acknowledge two things. One, the residual clause was enacted at a time when the clear statement rule wasn't as clear as it's become since then. Second, I think we're not asking this court to say that the residual clause can never apply. What we're saying is when Congress makes no reference whatsoever to the residual clause itself can't spring forward because it amends a statute that is referred to in the Affordable Care Act.
And where would you say that Congress would make reference to the residual clause in the relevant statute itself? Is that what you're saying?
That's what the Supreme Court has said.
So why would it bother to do that? I mean, it would just simply be easier just to make an express statement in the statute.
Exactly. In the Affordable Care Act, in Section 1557 would be where.
Well, that's one way to do it, but the other way to do it is this way. So I guess the question is, what is the residual clause? What work is it doing? I think at one point you may have made the argument that it only applies to statutes then existing at the time of the enactment. Do you still think that's correct?
Well, when you look at the legislative history, which is admittedly sparse, it does seem, and that is what the the legislature was talking about. In other words, it doesn't have to be. They said there might be other statutes. This was passed shortly after.
Are you aware? Are you aware of any? Are you aware of any other statutes?
Well, I can identify some other statutes for which the courts have not found a waiver, and the most obvious is cited in the reply brief is the Fair Housing Act. I'm not aware of any case that has said that's a statute that includes an anti-discrimination provision and it applies to projects that receive federal funding. I've not seen a successful case that argues that this waiver carries forward and captures that. In part because the critical question for a waiver of sovereign immunity is clarity both from the Congress what it intends and clarity for the state as to giving up its sovereign immunity. I mean, what we have here is Congress passes sort of a freestanding provision, the residual clause, that doesn't, as opposed to the 4 specifically named statutes where this court and others have said that's clear, right? Once you've named the statutes in the residual clause, even if it's afterward, the state's on notice. But sort of this vague language of any other statute. Then you move forward to some point in the future, in this case, in the early 2000s with the retiree drug subsidy, that completely, a federal funding mechanism that the state health plan receives through the expansion of Medicare. And then in 2010, suddenly when the command, oh, by the way, you've waived your sovereign immunity by accepting this money in 2005 because of this provision in 1986. And the position is Congress can't do that. Congress has to specifically look at the funding and the waiver and say to a state, this is the deal. And if it doesn't do that, it hasn't met the stringent standard of social. I also want to just tie on, because there's a specific statutory language in here that I think is important to just focus on, which is, Section 1557 talks about it refers to the enforcement mechanisms provided for and available under these other statutes shall apply for purposes of a violation. And the Supreme Court has specifically talked about enforcement mechanisms for Title IX, and specifically says that those are an administrative procedure run by the Department of HHS or private lawsuits, the implied cause of action. At no time did the Supreme Court in 2009, this is the Fitzgerald case, refer to a waiver of sovereign immunity as an enforcement mechanism. That term is not fairly included within the language that Congress used in 2010. I think that the critical point here, Your Honor, is that inferences are not enough, and that sovereign immunity is different. That if Congress wants to condition this, it can do so, but it must be explicit, and it must give the state an opportunity to see the bargain that's being made. And without that, I mean, you get circumstances like the question of 1986 for these residual statutes that would be swept up. Could the court analyze those? Could the court analyze that as a constitutional spending clause condition, or as coercive when there's no ability to know what's being demanded of the state, what's the funding stream, what's the existing funding stream? Those are all analyses that would go into a challenge like this.
Mr. Knepper, can I? Sorry, just another question. So is this an issue of notice, lack of notice? Is that the problem here, or is because obviously at some point the state receives notice and yet continues to insist that its receipt of federal funds shouldn't be conditioned on a waiver of sovereign immunity? So is it just simply because it's not direct enough that no amount of notice is sufficient to put the state to the burden of litigating in federal court?
Well, actually, that gets to sort of a part of the wrinkle that's here, Your Honor. There is a notice requirement under sovereign immunity. In other words, that's part of the test, that it has to be sufficiently clear to the state of what bargain is being made. And also, there's the clear statement rule. Congress has to be sufficiently clear in the text of the relevant statute that this is what it's demanding. But beyond that, one of the wrinkles that we have here is it's unclear and has been unclear sort of how this applies to states. I mean, Congress passed 1557 in 2010. In 2016, the Department of Health and Human Services said insurance is part of a health program or activity. At that point, two things happened. One, a group of states challenged, not including the state of North Carolina, challenged that 2016 regulation and received a national injunction. At the same time, the state of North Carolina says, okay, well, 1557 applies to us. We're going to make a change for a year and provide and comply with this particular. There are lots of provisions in 1557, but the specific one here relates to coverage of certain health benefits for individuals who are transgender, not other health benefits. In other words, the state's not suggesting that people who are transgender are not entitled to health care insurance because they're transgender. That's not. This is about specific benefits for specific treatment. At this point, the state adopts it for the one plan year. And then when it comes back, by that time, it's been enjoined, this particular application. And then in 2020, the Department of HHS comes back and says that rule no longer applies at all to health insurance programs. And so, and now that rule is being challenged. I don't want to make it sound like, that's, but I think it gets to the issue that the state has, which is the clarity that this is the kind, that you should have known that the retiree drug subsidy money meant private suits by litigants against state health plan or coverage decisions there's not really, the failure to be able to find a time when you can actually do that highlights the lack of clarity for the state. And clarity in a stringent test is what's required by the U.S. Supreme Court. Thank you.
Thank you. Mr. Gonzalez,
Thank you, Your Honor, and good afternoon. May it please the court, Omar Gonzalez-Pagan, and I will be arguing on behalf of the plaintiff appellees today. The question before the court is a relatively straightforward one. Did the North Carolina State Health Plan as a state entity waive its sovereign immunity as it pertains to liability under Section 1557 of the Affordable Care Act by accepting federal funds from the Department of Health and Human Services? The answer is yes. When Congress enacted the Civil Rights Remedies Equalization Act in 1986, Congress struck a bargain with the states. If a federal statute prohibits discrimination by recipients of federal financial assistance.
Counsel, are you arguing solely on the basis of the residual clause in the 1986 statute, meaning you're not arguing that 1557 on its own acts as a sovereign immunity waiver?
No, Your Honor. We are arguing that actually the Civil Rights Remedies Equalization Act has waived sovereign immunity here in two ways. First, Section 1557 falls squarely within the statutory language of the residual clause of CREA. But alternatively, it incorporates both the grounds and the enforcement mechanisms of Title IX. And the waiver of sovereign immunity and liability to sue by private citizens under Title IX is one of those enforcement mechanisms that is incorporated into Section 1557 itself explicitly.
Well, as far as the residual clause is concerned, it's been around now for, I guess, 35 years. Has any court of appeals ever found that to act as a waiver of sovereign immunity?
No, Your Honor, and that is because there has never been another spending clause legislation that was covered by that residual clause, which was intended to obviously apply into the future. There are only 5 statutes, at least to my knowledge, that prohibit discrimination by recipient of federal financial assistance. Those are the statutes enumerated in the Civil Rights Remedies Equalization Act and incorporated into the ACA Section 1557.
So does the spending clause take that type of case out of the Supreme Court's clear, unending admonition that that a waiver of sovereign immunity has to be clear, can't be implied, can't be inferred, has to be self-evident? Is this a special subcategory of sovereign immunity?
No, Your Honor. We believe that the admonition from the Supreme Court and the caution that it has given is that the waiver of sovereign immunity be clear and unequivocal in the relevant statute, and that in statutory language. And this court, both in Littman and Constantine, as well as the Supreme Court in Franklin and Pena, Lane v. Pena, have recognized that the statutes enumerated in the Civil Rights and Remedies Equalization Act, they don't contain a specific provision within that statute, but that the relevant statute for purposes of evaluating the waiver is the Remedies Equalization Act. And in fact, in Littman, this court read Title IX in conjunction with the Civil Rights and Remedies Equalization Act. In Constantine, it did the same with regards to Section 504 of the Rehabilitation Act. And that is exactly
right. But those sections are specifically enumerated before the residual clause. So, for instance, the Second Circuit, I think the name of the case is Cronin, looked at this and said, well, the residual clause can't act as a waiver of sovereign immunity. Why else would the Congress have listed these other statutes specifically?
Well, at the time, there weren't any other statutes, to my knowledge, that fell under the purview of the residual clause, but this is a statute that falls within the four corners of that. The residual clause prohibits, it specifically leads to the conclusion that the provision of any federal statute prohibiting discrimination by recipients of federal financial assistance. That is exactly what Section 1557 of the Affordable Care Act does and is. It is the only, to my knowledge, federal legislation that falls within that residual clause. It doesn't.
What's your best case? Because I'm not aware of any where sovereign immunity is approved without a specific statutory reference in the statute that does the waiving, that denominates that statute by name. What's your best case for the contrary proposition?
I do not have a case for the proposition that it be named by name, nor I believe there is a case to the contrary either. I believe that is an open question that has been left open by both the Supreme Court in Tossaman and this court in Littman in Madison. And ultimately, the reality is that the statutory language there is quite clear as day. Any statute that prohibits discrimination by a recipient of federal financial assistance. That is exactly what Section 1557 is. That waiver occurs when you read both that statute in conjunction with Section 1557, which is what this court has done with Title IX and CREA and the Rehab Act and CREA. I additionally would posit to the court that there is the argument about whether this is an enforcement mechanism that is both provided for and available under Title IX and likewise incorporated into the Section 57 of the Affordable Care Act. We would argue that it is both provided for and available under. In fact, the private right of action under Title IX is not even delineated in the statutory language of Title IX. It was recognized by the Supreme Court as an implied right of action, and thereafter created the waiver for CREA as recognized in Franklin. And that the Supreme Court has stated in United States v. Georgia that Congress's enforcement power includes the power to abrogate state sovereign immunity by authorizing private suits for damages against the states. And this court has also referred to in Littman as the waiver of sovereign immunity as a mechanism to enforce the statute. And so we believe that it is an enforcement mechanism that has been incorporated through the enforcement mechanisms of Title IX into Section 1557. And I don't believe this. The plan has argued that Title IX does not waive sovereign immunity and that it is not subject, the state would not be subject to suit under Title IX. Your Honor, I would also posit for the court that the conduct of the plan in this case is indicative of the reasonable state expectations when the Affordable Care Act was passed, and as to the bargain that it had struck. As soon as the Affordable Care Act was passed, and in evaluating the Section 5057 provision, it started evaluating whether it needed to eliminate the exclusion. It actually did for the year of 2017, specifically stating that not doing so, they would have faced discrimination losses for noncompliance. That's a quote from one of the state officials, and it is in the complaint in paragraph 50, joint appendix pages 31 and 32. And in addition, they continue to represent to the public themselves through their Section 57 procedures that are posted on their website, that they are indeed subject to Section 57 and may be subject to suit in court for violations of that statute. We believe that that is indicative, not because it's a subjective test, but it's indicative of the reasonable state official that would read this. And any state official who reads Section 1557 in conjunction with the Civil Rights Remedies Equalization Act would come to the same conclusion as this court held in Letman. Finally, Your Honors, unless there are any other questions, I would just address the point about the question of whether the health plan is a program or activity. First of all, we would argue that that is not a question before this court. Before this court is a threshold question of whether they have waived sovereign immunity at this court based on a collateral order appeal. And in any event, that goes to the merits. But even if we were to address that, the statutory language in Section 57 is unambiguous, and the 2020 rule is not subject to deference in that instance. It applies to any health program or activity. It defies common sense for them to argue that a health insurance program plan is not a program or activity related to health. In any event, those are being challenged, as counsel acknowledged, in court, and that challenge includes the state of North Carolina, who is a plaintiff suing the Department of Health and Human Services, arguing contrary to the position that counsel has put forward today. And that is in the lawsuit, New York v. the Department of HHS, Department of Health and Human Service in SDNY, and it is referenced in our brief on page 28.
Mr. Gonzalez-Pagan, I wanted to follow up with you on this issue of waiver, and in particular, the 10th Circuit's decision in Levy versus Kansas Department of Social and Rehabilitation Services. So part of that holding, the court there said that to be a knowing and voluntary waiver, it can't be hidden in another statute and only applied through implication. So obviously you disagree with that, but separate from that, I think what Levy pointed out was that it's also relevant to decide or consider whether or not the statute in question is laser-like focus on discrimination, or whether it has a broader focus other than discrimination. I suppose the argument here is that the ACCA has, as part of its component, obviously an element of eliminating discrimination, but it's much broader than that. It deals with healthcare issues and the like. So why isn't that analysis applicable here? We don't have a statute that deals exclusively or primarily with discrimination. It's much broader, and we have this issue of finding a waiver by implication. Why doesn't the combination of those two things warrant a different result, but the same result here?
So I will address, I have two responses to that, and I will address first the issue of implication. This is not an issue where there is a waiver by implication. There is an explicit waiver that has been demanded by Congress in the Civil Rights Remedies Equalization Act.
Well, but that was also the case in Levy, right? There was.
No, Your Honor, and the distinction is as follows. Levy involved the American with Disabilities Act, and there's another case that was referenced by counsel in their brief involving the Fair Housing Act that they alluded to during oral argument. Neither of those two cases are applicable because neither of the statutes fell within the four corners of the Civil Rights Remedies Equalization Act. While those statutes prohibited discrimination, they did not prohibit discrimination pursuant to a spending clause to a recipient of federal financial assistance. Rather, both of those statutes, the American with Disabilities Act and the Fair Housing Act, were statutes enacted pursuant to Section 5 of the 14th Amendment. And in those circumstances, the Supreme Court has demanded, has both found that there is a possibility for direct abrogation by Congress to the extent that it's concomitant with the Equal Protection Clause, but that it must be explicit in those statutes. Those statutes did not fall under CREA because they were not statutes that were prohibiting discrimination by a recipient of federal financial assistance. That's the first answer as to the question of implication, Your Honor. And pardon me, Your Honor, I just blanked on your second question, if you don't mind refreshing that.
Well, the second part of it was the fact that the ACCA, just like the statute at issue in Levy, was much broader than it dealt with topics much broader than discrimination.
Correct, Your Honor. And that is true of some of the statutes that are addressed in the Civil Rights Remedies Equalization Act. The Rehabilitation Act dealt with much more than just the elimination of discrimination based on disability. It actually authorized a number of other programs, and that is in fact why we keep referring to Section 504 of the Rehabilitation Act rather than the Rehabilitation Act as a whole. And in fact, that is also true of the Title IX amendments to the Education Amendments of 1972. Not all of the provisions dealt with discrimination, and some of them authorized independent programs. Ultimately here, the Affordable Care Act is a statute that is aimed at ensuring access to healthcare and improving that access. Part of that is the elimination of discrimination in healthcare, and the Section 57 is part and parcel, and indeed, essentially in part to that very purpose. However, I would posit that there is no requirement that I have seen that simply referring to a statute means referring to an entire public law as opposed to a specific statutory provision within an entire public law. We know that in the modern age of legislation acted by Congress, those bills tend to be multifaceted and incorporate multiple bills into one when it comes to passage. And to demand that, I'm not aware of any authority that demands that the bill deals solely with the issue of discrimination in order for it to be covered by the Civil Rights Remedies Equalization Act.
1557 takes you directly to Title IX, Title VI, the reference, not implicitly, but explicitly, correct?
That is correct. It both explicitly incorporates the grounds and enforcement mechanisms of each of those four statutes. That would be one of the alternative argument, which we believe that Section 57 has that explicit waiver by incorporating those mechanisms. But in any event, we would also argue that it can be read in conjunction with the residual clause of the Civil Rights Remedies Equalization Act. Your Honors, if there are no more questions, at the end of the day, the inquiry before the court is whether the state health plan is able to ascertain what is expected of it in return for federal funding from the Department of Health and Human Services. From a factual perspective, any reasonable state official or state agency, as the state health plan did here, would have known what was and is expected of it in return for federal funds. From a legal perspective, any state reading Section 57 in conjunction with the Civil Rights Remedies Equalization Act, or just knowing the enforcement mechanisms incorporated for Title IX, knows what is expected of it and in return for federal funds. We urge the court to affirm.
Thank you, Mr. Gonzalez-Pagan. Mr. Knepper?
Thank you very much, Chief Judge. I think I'm going to try to address two or three of the issues that came up. The first is the question about sort of interpreting the residual clause. Your Honor, this is the same kind of separation of powers issue that's presented in other residual clause cases. So, for example, under the Immigration and Nationality Act, the Supreme Court has said a crime of violence is not something that Congress can delegate that interpretation to the judiciary. that it is up to Congress to make that decision. Even if you could say this might be a crime, even if there could be agreement that this particular action would qualify as a crime of violence, the Supreme Court said that was too much under Sessions v. Pereira. That was Justice Kagan in 2019. And our argument here is the same, that the courts the Congress is the one that has to do it, not simply by a broad reference that the courts then go out and attach to various funding streams based on other statutory commands. Second, to be clear, Section 5057 is not a dead letter even as to the state of North Carolina. I mean, there are still enforcement mechanisms available. There are grant restrictions that are possible. There's no question that they remain available. And the United States, there's no barrier to suit by the United States in any circumstance. So the question is a more limited one, which is, did Congress intend that suits by private parties in federal court be available as a condition of this funding? So I don't want to leave the impression that the state of North Carolina's position is, or that if efforts to comply are irrelevant, but that doesn't answer the specific issue of federal jurisdiction here. Finally, I would just note that in response to Judge Diaz's questions about sort of the broader statute, that has been the approach in other areas, and to the extent that Congress thought a different thing should apply, they specifically identify, Section Title IX, Title VI. But the courts, both the Fifth Circuit and the 10th Circuit and Levy, have both said, if you're going to sort of draw it more broadly, that statute has to be one solely focused. And to be fair, that is the reasoning that the Supreme Court adopted in Sossaman with regard to the RLIPA, which does have in Section 2 language prohibiting discrimination in land use, but the court didn't say therefore the court said, well, but Section 3 has more, and then the court said all of RLIPA there's no waiver of sovereign immunity demanded. And to the best of my knowledge, there's never been a court that has said, in fact, there's a district court in Maryland that has said the opposite. There's never been a court that said, well, that was only for Section 3. There still could be application of the residual clause for Section 2 of RLIPA as to land use planning. That argument's never been made or adopted in the 10 years since Sossaman.
Well, that's because in that statute, it dealt with not dealing with protection or discrimination in terms of services. In fact, it was giving more protection to regard rather than more. So it was not that it was trying to discriminate, but it was giving more protection. So it wasn't the whole theory, if you will, the purpose of the statute was not related to preventing discrimination. Instead, it empowered them to do more things because of the religious practices.
Your Honor, and the two things I'm pointing out are, one, that the denominator that was looked at was RLIPA, not just Section 3. In other words, the court's result was all of RLIPA, not just Section 3 of RLIPA, which deals with prisoner litigation. And second, the denominator here should be all of the Affordable Care Act, not simply Section 1557. And then the other point is that in Section 2 of RLIPA, there is actually an anti-discrimination provision. It says, so in addition to the heightened standard, it also says that there shall be no discrimination. So it goes. You're right. It goes beyond, absolutely. But so does the Affordable Care Act, which goes far beyond simply being a federal statute. All right. Well, thank you, Your Honors. Thank you, Your Honor. That's all. I'll sit down.
Thank you, Mr. Nepper. Thank you, Mr. Egon. I can't come down and greet you, but no, we appreciate so much your argument, and both take care. Stay well. Thank you so much.
Thank you very much.
I'll ask the clerk of the court to adjourn the court, at least this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Judges, I will move you to the robing room now.
Thank you.
Thank you.